Thank you very much for attending this session today. I'm Shazia Dyer, I'm a director at Bristol Law Society. This is our second in-house lawyers conference. We will be recording it and we will send you a link after the event. I'm sure you'll agree we've got a stellar lineup today. When we were considering what to put on for this session, we decided we wouldn't do professional legal training. We may do that as a separate session later next year. But what we wanted to do was look at lawyers as individuals, as a professional working in a post-pandemic world in what is a very challenging time. So what we brought for you today are a number of speakers. Most will talk about resilience and well-being because we believe that is really important to us as a profession as a whole. We also have a speaker on climate emergency and what we as law firms and in-house lawyers can actually do to help reach net zero. So, climate emergency, it's an absolutely crucial part of what we do on a day-to-day basis. The area that I think is really innovative and far-reaching for our region is legal technology. So legal tech for our region, I think, is important, mainly because we are the fastest growing legal sector outside of London. And if we want to keep that cutting edge and we want to be at the forefront of all the innovation for legal services, then that's something we really need to grasp and take hold of. And we have the potential to do that. So what we want to do is bring that to you today and look at how we can all work together to make that a reality. We've also got a speaker on the ethics framework, which we all work under, and that obviously encompasses everything we do. And then we've got a couple of speakers who will tell us about their lived experience of working in the public and private sector in-house. There are lots of similarities and lots of things we can learn from each other, and the transferable skills, all of those things we can look at. There is a Q&A function at the bottom of your screens. If you could put any questions in there, what we'll do is we'll pick them up after every speaker has spoken. So Stephanie, if you're okay with that, I'll keep an eye on it and we'll take each speaker in turn and then look at the questions after that. So just before I do pass over to our chair, Stephanie, I would like to thank all of our speakers today because they've all given up their time, not only today, but in terms of preparation. So we're very grateful for that. Thankfully, we didn't have to travel anywhere, so petrol wasn't an issue. I'd also like to thank our sponsors, Hayes Legal Recruitment, for today, and a very special thanks to Claire Ponting at Bristol Law Society. She's actually been behind organising the whole event. She's doing all the IT today. Remarkable, all the dedication and organisation. Without her, we wouldn't be here today. So thank you to Claire as well. So on that note, can I please pass over to Stephanie Boyce, President of the Law Society.
Thank you very much, Shazia. So good morning, everyone. It is my pleasure to be with you all today and a privilege to be chairing Bristol Law Society's in-house conference. I know we are set for an insightful and wide-ranging day, touching on all aspects of in-house practice. So from ethics and governance to decarbonisation and how to maintain your own well-being. I'm sure everyone will leave today filled with new ideas and concepts to implement their work. I would like to begin by speaking about diversity in our profession and why it is fundamental to the profession and its future. This is true whether you are an in-house practitioner, an international firm, or a local legal business. Driving diversity and inclusion is one of the priorities for my presidency. I took up my role as an office holder of the Law Society of England and Wales in 2019 and succeeded to the presidency in March of this year. And in doing so, I became the first person of colour to hold the position of president. I'm also only the second in-house solicitor to be elected as an office holder. So I intend to bring a fresh perspective to the presidency, an understanding of the experiences of underrepresented groups and what we must all do to support them. In my presidential term, I will continue the Law Society's work with law firms, legal businesses, shared services and other organisations to open up access to the profession to those from non-traditional backgrounds. It is my ambition to leave the profession more diverse and inclusive than the one I entered, but I'm clear that this must be a joint endeavour with each and every one of us playing our part. But that's not to say that the profession has not made good progress towards becoming more inclusive. it is clear that across much of the profession, this goal is a shared one. But there is still more to do. Solicitors exist to serve our society, and to do so effectively, we must be reflective of society too. In doing so, we can ensure we maintain the faith and trust of those we work for and are continuing to attract the best talent from all backgrounds and communities. A recent Law Society member survey found that 52% of solicitors are female, practicing solicitors are female. 17.5% of solicitors are from a Black, Asian, minority ethnic background, and 5% are LGBT+. The Law Society has used these figures to produce a diversity profile of the solicitor's profession, which provides a range of information on all aspects of diversity against which firms and businesses can assess their own profiles. Women now make up over half of practicing solicitors and 63% of new entrants. However, while those figures are promising, the data also shows that inequality persists at senior levels. Women make up only 31% of partners in private practice, and the pay gap remains a problem, particularly at partner level, with pay differentials between men and women far exceeding the national average. And we have seen increases in the number of Black, Asian, minority ethnic and female solicitors, but there is still underrepresentation at senior levels, and there is still work to be done to encourage upward mobility. In 2020, the Law Society launched its Race for Inclusion report into the experience of Black, Asian and minority ethnic lawyers to shed light on the challenges they are facing and the practical steps that can be taken to support them and build a more inclusive profession. Our report found that 8% of partners in the largest firms are from a Black, Asian, minority ethnic background, and that figure has only risen by 1% since 2014, and there is a significant ethnicity pay gap, with the average salary for white solicitors at £36.13 per hour, compared to only £27.01 per hour for Black, Asian and minority ethnic lawyers. There is also still quite a significant difference between the socio-economic diversity of the profession and the wider working age population. While only around 33% of the working age population come from professional backgrounds, meaning their parents were in an occupation classified as professional rather than intermediate or working class. In the legal sector, this figure is 58%, rising to 60% amongst partners in law firms. Solicitors are much more likely to have attended independent fee-paying schools than the wider workforce too. 23% compared to just 7% of the working age population. And we will shortly be holding a webinar on how firms and businesses and members can encourage staff to be more open about discussing class in the workplace. I would encourage everyone to look for details on our website and consider taking part. The Law Society has been carrying out research to help our understanding of the experiences of LGBT+ practitioners. We recently carried out a survey to look into this further. Our findings illustrate a welcome shift in attitudes towards LGBT+ equality and visibility across the legal sector. The majority of those surveyed said they were able to be their authentic selves at work with support from colleagues and senior staff. 97% of LGBT+ respondents felt able to be themselves in their workplace, either sometimes or always. However, the survey highlighted areas where we must improve. Alarmingly, 37% of LGBT+ respondents had experienced homophobia, biphobia, or transphobia in their workplace. 52% of LGBT+ respondents said there was a lack of positive LGBT+ role models at work. We know that visible role models can inspire us to reach our goals, as well as providing opportunities to share challenges and successes. It is important we reflect on these findings and the window into LGBT+ experiences that they provide. To better understand the lived experiences of disabled people within the profession, the Law Society's Lawyers with Disabilities division has been working with the Legally Disabled research team based at Cardiff University. And this project has put forward recommendations on how to create a more inclusive culture for practitioners with disabilities, including greater facilitation of work experience opportunities and outreach efforts, as well as creating greater understanding of reasonable adjustments that can often easily be put in to support employees. A key element that attracts people to a profession is seeing that it recognises the value of their experiences and perspectives, that it does not expect or require particular backgrounds or connections. It is a responsibility that lies with all of us, and there are steps we can all take to build an inclusive, diverse and equal workplace. And we need to begin by recognising and acknowledging that everyone, men and women, have unconscious biases, so that we can work to counteract them. Ways to address and mitigate unconscious bias include evaluating recruitment selection and promotion processes so that they measure relevant competencies fairly and without adversely impacting on any one group of candidates. Businesses should employ appropriate allocation processes to ensure that women and men have equal access to the most valued work and devise objective salary structures that everyone is paid fairly and according to skills and contribution. In addition to the mandatory gender pay gap reporting, ethnicity, disability and socio-economic background pay gaps should be monitored, giving us a more comprehensive picture of the level of equality in organisations. Additionally, diversity and inclusion should be placed at the centre of all business planning, prioritised in the same way as other fundamental strategies. The Law Society's role is to represent and support our membership, and in encouraging diversity and inclusion, we are working to drive change too, whether through our social mobility ambassadors or our diversity access scheme, which has supported and funded nearly 250 people from lower socio-economic backgrounds who want to join the profession. The Law Society is at the forefront of making our profession open and diverse. We are also helping our members to commit publicly to promoting the values of diversity and inclusion throughout their businesses via our Diversity and Inclusion Charter, which we encourage organisations to sign up to. And for those seeking to take their career down the judicial route, we run complementary Becoming a Judge workshops for ethnic minority solicitors, giving this underrepresented group practical advice on completing the application form, as well as interview practice. We also have a dedicated ethnic minority lawyers division committee, which helps us build our community of ethnic minority lawyers and shapes our race diversity strategy through its engagement programme with local law societies, universities and businesses and firms to raise awareness of race inequality and how to tackle it. From these initiatives, you can see the vital work the Law Society is leading in this area, much of which is centred around providing a platform for role models who can share their experiences and paths they took in their careers to inspire others to follow in their footsteps. So I am heartened by the progress we have made so far, and I'm energised by how we will be able to build upon these foundations and continue to support the profession as it becomes ever more diverse and inclusive. Thank you very much for listening to me today, and it's been a privilege to address these important issues. Before I end, I would like to encourage everyone to engage with the varied and interesting content and sessions that we have lined up for you today. I hope everyone will also make most of the virtual networking opportunities available, and it is just as important to learn from those around you as it is to hear from our excellent speakers. I'll now hand over to Harriet Chapman. Thank you and enjoy the conference.
Thank you, Stephanie. That was fascinating, really, really interesting. Thank you for that. Good morning, everyone. On behalf of Hayes Legal and Bristol Law Society, a very warm welcome to the In-House Lawyers Conference, and a big thank you again to Claire for her fabulous organising. She's been a superstar. So thank you for joining us this morning. My name is Harriet Chapman. I'm a senior manager here at Hayes Legal. Don't worry, I'm not going to give you war and peace on the legal recruitment market, but Helen has asked us to provide just a very quick snapshot of the legal job market, as it's fair to say it's been through a fairly turbulent period in the last 18 months. So despite an initial hiatus when COVID first hit, following the first lockdown, in-house legal recruitment actually remained consistent throughout the latter part of 2020 and throughout into 2021. So even throughout lockdowns 2 and 3, this has come as a surprise to many people that I've spoken with. The demand for legal talent has always been high and outstripped supply. However, as a team, we are currently experiencing the highest levels of job instructions on record, both in-house and within private practice. A couple of key points to highlight. We are currently seeing more flexibility with regards to clients' requirements when hiring. For example, recently we've had several hiring managers who are looking to hire, for example, into their commercial teams, willing to consider litigators who are perhaps looking for a career change. I'm also seeing more and more clients looking to make first-time legal counsel appointments, particularly within the tech sort of specialism. And also far more hiring was usually going on at the NQ to 2 level. So historically, most clients have wanted to hire at the sort of 4 or 5 plus mark, but we're really seeing a lot more junior opportunities come onto the market. Remote and hybrid working is one of the biggest changes undoubtedly to have emerged from the last 1.5 years. And if you aren't able to offer this to your employees and prospective candidates, you are going to struggle to compete for talent in this market. In light of the demand for good quality candidates, it's no surprise that salaries have also risen and continue to rise. As an example, I recently had a client increase an offer by an additional £40,000 on the base salary in order to secure a candidate. So crazy goings on at the moment. A key message for anyone that's looking to recruit, I cannot stress this enough, is the importance of moving quickly. Many of our clients are currently fast tracking processes by combining first and second stage interviews, or making an offer after one interview and then bringing candidates back for another more informal meeting, or even into the office. It is happening again now. So perhaps for a further meeting with other team members or a coffee, for example. However, remote interviews are definitely here to stay, so it's really important that you have a good process in place for this. Make sure it reflects your culture and the brand values that you want to get across. In short, we are currently working on some fantastic roles at the moment, so now is a great time to be considering your options if you are looking to explore what is out there. It's certainly a candidate's market. Just a little bit about us. So I'm based in Bristol and cover the South West and South Wales market. In the Bristol team between us, we have over 17 years of legal recruitment and legal experience, some more than others, but I'm not going to say who. And our information is drawn from Bristol and the South West. However, we do have a network of legal teams across the UK, which includes Manchester, London, etc. So we are able to support on roles or moves throughout the UK. And next slide, please, Claire. I'm aware that this has been a whistle-stop tour, wanted to keep it short and sweet for you. However, I have included my contact details on the slide, and I'm very happy to follow up direct with any of you that might want to ask further questions, or indeed now. But many thanks, and enjoy the rest of this morning.
Thank you very much, Harriet. James Cassidy.
Good morning, everybody. It's an absolute privilege to be here to talk to you today. My name is James Cassidy. I'm a partner at Bevan Britton, and myself and my colleague Victoria are going to give you our views on the differences between working in-house in the public sector from our experience and then working in private practice. take into account the difference in the law, the difference in things you have to do the job, but also the difference in working in the different sectors. I've worked in-house in the NHS, and Victoria was in local government, and whilst our experiences between the two of us were very different, we've got our heads together to think about the key differences between working in-house and in the private sector, which I hope is of interest. We haven't got any slides because we thought it's more of a kind of informal chat, and so if you do have questions, please do pop them in the Q&A. I'm more than happy to pick them up at the end. So in terms of my background and how I've worked in both private practice and the public sector, I actually qualified as a solicitor in private practice actually at Bevan Britton, where I work now. I trained in the Birmingham office, then I moved to the London office and worked there for a few years. Then I worked for a city firm for 5 years. And at that point had the opportunity to go on secondment into an NHS foundation trust to be their head of legal on an interim basis. Having been there for a few months, I decided I enjoyed it and then joined for 3 years and was head of legal at Moorfields NHS Foundation Trust, which is the specialist eye hospital. I worked there for 3 years before then returning to Bevan Britton. So I've come full circle a few years ago, and now I'm based in both London and in Bristol. I now specialise in information law, so my team deals with data protection, GDPR, freedom of information, EIR, and the wider information law aspects. I work now both for private clients or private sector clients and a lot of public sector clients as well. So hopefully I've got an equal split between the two and can just take you through, from my perspective, having worked in both and enjoyed working in both, some of the key differences between the two. Now, having looked at some of the attendees today and looking at the kind of range of different organisations you work for, it's very difficult, and your experience will always be dependent upon the nature of the business you work in, the size of the team you're working in, your role in particular, the area of law. But I'm going to take you through some of the key issues I think that both Victoria and I found were particularly interesting working in both the public sector and then back in private practice. So I think one of the key ones really from my perspective is the different legal obligations that are placed on public sector organisations that sometimes the private sector just don't have to deal with. And there's some stark issues that really put pressure on the public sector. You know, examples of procurement regulations, judicial review mean that there are extra obligations to consider that the private sector wouldn't have to consider. There are extra public law obligations which effectively require you to do certain things in certain ways. And a lot of the differences between the two are because you are in the public sector publicly funded. On that basis as well, one of the other issues is that you're creatures of statute, certainly in the NHS, that a lot of your functions and powers and obligations are set out in a raft of complicated, interrelated statutes, regulations, directives, all sorts of different obligations there. And you need to understand where they all come from and what you can and can't do and where your powers are. Again, the private sector, you have similar obligations, but I think as the public sector, it's an ever-changing map of different statutes and regulatory functions that will apply to you. On the back of that as well, I think you also have guidance, which I think is an important part to play. Certainly, we've talked about judicial review. You need to demonstrate in terms of JR, and I don't do JR anymore, but that you are following guidance, or if you haven't followed guidance, you've got a good reason to depart from it. There is guidance from all sorts of different places that comes together when you're in the public sector that you need to consider. So having worked in a foundation trust, you have to consider guidance from the CQC, the Department of Health, NHS England, NHSX, Information Commissioner's Office, the HRA, the HTA, all sorts of different places, lots of different stakeholders provide guidance for you to think about. And it's a matter of having a kind of broad knowledge of all these different obligations and requirements and pulling them together in terms of being able to provide helpful practical advice in-house, because you do need to understand that function and where you sit as an organisation in this regulatory and statutory framework. It's a complex job to navigate because it's constantly evolving, but certainly that's one of the key issues that I found very complicated initially to get involved with, is understanding the different dynamics of all these different issues. Alongside those sort of legal issues, there's also the kind of commercial, relatively obvious things, but the kind of commercial power that you have, money. In public sector life, there is a budget, and sometimes when that budget isn't there, it's gone. And I know that's the case sometimes in private sector as well, but certainly, my obligations as head of legal were to be very mindful of budget and I would try and do as much stuff in-house as possible. Equally, you often find that the public sector, or certainly when I was in the public sector, using external lawyers was often a distress purchase. So you get to a point where you have to get some legal advice, you need the support, you haven't been able to resolve it, you need to go to lawyers. I think often in the private sector, and working with private clients now, sometimes they're a bit better at being able to look down the line and say, well, what's coming? Where do we need to take proactive steps to respond to things before letting it get to the point where we need a response? Now, that depends on what kind of law you do, but certainly in my experience of being in the healthcare sector, that was often the case. I think one of the main differences for me, really, particularly being an information lawyer, is the kind of expectations in working in the public sector and advising my client when I was in-house on what to do, what not to do, what issues to take into account. The obligations of transparency, openness, accountability, the duty of candour, all weigh very heavily on the public sector, and is a very important factor to consider when making any decisions about legal issues. And obviously you've got privilege that applies to these things, but in terms of looking at the wider sector and the wider obligations, everything you do effectively has to be accountable. And there is a great expectation that what you're doing and why you're doing it is open to being interrogated, and you can justify your position. Even worse, I think when things go wrong, you are required under the duty of candour in the NHS to effectively own up, potentially tell people what's happened when things have gone wrong. Now that's a complicated dynamic to deal with when you want to be able to deal with things and advise your internal client on things that might be very complicated and sensitive. Things have gone wrong, and then immediately you have to be telling people, which means that individuals need to know about it, regulators get involved. That's the right way of doing it. But I think the dynamic between the two and the timings between the two, and having the space in which to feel free and frank about looking at what went wrong and what you can do about it, can be a tricky balance. And then on top of that, I suppose not only are you expected to be transparent, there are times where you can be forced to be transparent. Information lawyer, FOI, EIR are both onerous obligations where you have to be very careful about emails that get sent around, comments that get sent around, documents that get marked up. All these things can potentially be disclosable under FOIA. Yes, as I said, if you're advising as a lawyer, privilege would apply, but often things get shared more widely, and often you're not necessarily advising as a lawyer. It's not legal advice. It can be far wider in terms of your role in public sector. So I think from those elements, everything you do is in the back of your mind is, oh, this is going to need to come out potentially, or could come out, or could be shared, or could be discussed. Now that's, if there's a kind of incident that happens, then that's fine. If it's commercial issues and you want to try and be more commercial at what you're doing, it can be a complicated balance to strike between the two. And then I think also transparency impacts on reputation. And I think the reputation of the public sector is equally important in the private sector. But I think, again, because of the obligations of transparency, the obligations that you're placed under due to FOI and EIR, the managing reputation, managing comms, managing how you deliver messaging is vital as well. So what this means in practice, I suppose, is an interesting question, and Victoria is going to come on now to talk about some of those key differences. But from my perspective, when I was in-house, I was one lawyer out of one. There was only me. Effectively, I had some support from different people, but I was the one lawyer. Now, that's very different if you're in a big organisation with lots of different lawyers. But certainly, the difference was that you are effectively a general counsel. I was certainly acting as general counsel, and that I wasn't just getting involved in the legal stuff that you would do now in private practice. I always had a far wider role, which is something I really enjoyed as a kind of trusted advisor. I was getting involved in all sorts of different things to give my views on, and as a lawyer, sometimes you look at things in certain ways, which can be helpful, sometimes unhelpful, I accept entirely. But actually, it's much more part of risk management and management more generally of the hospital, which was fascinating. As I said, I loved working in the public sector. I think certainly there are benefits and pros and cons of both, but enjoyed both very much so. I think you get a real benefit. The one that you get in private practice, in working in-house, is that you get under the skin of an organisation because you have so many touch points with individuals who work in that business. People just knock on your door and ask you questions about all sorts of things. And from my experience, 9 times out of 10, it wasn't really a legal question, but you get to understand what the issues are for the organisation, which helps you assess risk and helps you understand a bit more and advise and be that trusted advisor. But certainly, I think having worked in both, I think there are lots of skills that are transferable between the two. And vice versa. So if you're in private sector, I think equally public sector would benefit from your skill set and vice versa. So that's all I wanted to say for now. And I'm going to hand over to Victoria, who's going to talk about the sort of other elements and the difference in practical terms in working in the two. And then we'll come back for any questions there might be at the end. Victoria, over to you.
Thank you, James, for that intro there. So as James said, I'm going to talk a bit more about the experience side of things. Obviously, James has talked a lot about the legislative framework difference. We have had a question: what advice would you give to a lawyer looking to move to an in-house role for the first time? And hopefully I'm going to cover that to an extent, if not necessarily directly. So a bit about me. I started my career in the public sector. I trained at a local authority in Yorkshire. Then I worked for Leicester City Council for a period of time. And before I then went to the London Borough of Haringey, where I worked for nearly 10 years before jumping to the dark side, shall we say, and to Bevan Britton, where obviously I'm now, based predominantly out of the London office, but also out of Bristol as well. When I was at Haringey, I started as a contracts and commercial lawyer, and then I specialised in governance, where I managed a team of lawyers, and I worked really closely with the monitoring officer, chief executive and senior directors, as James said, really getting under the skin of the organisation there. And I specialise now, continue to specialise in local authority corporate governance, advising on diaries, constitutional issues, governance, democratic process, policy development, financial framework, and major projects. So that's my background, a bit about me. So role then, what's it like being in-house versus private sector? Quite different. Similarly, lots of similarities, but really quite different. When you're working in-house, you're no doubt going to find that you're not just trusted legal advisor at all. You're also the confidant, you're the risk advisor, you're the agony aunt, you're the firefighter, you're the project manager, and you're also probably going to be the PR and comms advisor at some point, amongst other things that I've probably not mentioned. And this is where you can really add value, as James said, building those relationships and developing that trust with your internal clients so that you can really get to the heart of advising on any given matter and really guide and influence as you go along, rather than just simply being parachuted in at the end if something goes a bit awry. You really need, I think, in the public sector, you really need an understanding of the climate that you're working in. Private sector clients might have greater or seemingly infinite resources to facilitate whatever it is that they're trying to achieve. But in the public sector, as James has alluded and touched on, it's really obviously very different. And the decisions really need to reflect a variety of issues. There's much tighter statutory controls, obviously, on the public sector to protect the public purse. So the budget is a huge factor. There's also the politics to consider, and whether that's the central government initiatives that are constantly changing that you then have to implement, or whether it's the local administration where you work. You know, working in a Labour-run council is going to be a very different experience with different priorities, different challenges to working in, say, a Green or a Conservative council, or a council with no overall control. And working in an organisation with a different administration and priorities to central government as well brings, of course, its own conflicts where maybe those policies don't quite align. I remember it being really challenging when I was at Haringey, when the coalition came in, and the the spending review then that we got in 2010, and having to basically cut the budget by 42 million before we set the budget in April. So we had about 3 months to cut the budget by 42 million, and that was in a Labour-run administration. So that was really challenging and very difficult. And you know, there are also all the rules which I haven't really gone into on comms, political comms, and the publicity code, and what you can and can't say in those public documents that are coming from a council, to make sure that you're not unwittingly influencing the voter. So the politics side of it really is key. Makes it very interesting, I have to say, but it does add a whole different complexion to your work. Obviously, we all know that funding is a key issue for the public sector, and understanding how that really influences and shapes decision making is essential, because you've got to try and find the best route in light of all these conflicting priorities and conflicting issues. You've got your commercial ambitions versus what resources are available, the political priorities to weigh up versus what's happening centrally. And also the reputational risk, whether that's because the authority that you're working in maybe and your organisation may have faced criticism for this sort of thing in the past, or perhaps because of what's happening locally and nationally, and how things play out in the media has a potentially very significant role to play in deciding how best to advise. You might find that you then having to clear the comms pieces before they go out. You may have a comms team, you may not. You may need to really support them with press releases that are going out and all that sort of thing. So it's much wider in-house than just the law. Personally, I find, as I'm sure James does too, that my in-house experience really helps me to understand where my clients are coming from. That's one thing that I think sets us apart a bit, and understanding the politics of the authority that I'm advising, not just politics with a big P, but politics with a little p as well, and able to advise holistically rather than just commercially. I mean, that's not going to help as an external lawyer supporting a local authority or the NHS. Just advising commercially isn't enough. You need to be able to advise holistically with all of these other issues taken into account as well. In terms of your client base, then, of course, in private practice, you've got a multitude of different clients, but in-house, of course, you've got lots of internal clients with their own internal pressures that don't always align with one another, and that's a difficult thing to balance and manage. In terms of disciplines, you'll find in-house that you're often required, obviously, particularly where you work in a smaller team, as James said, he was a team of one, to work on a range of different disciplines, and that makes the role really varied and interesting, but it brings its own challenges as well, because you have to get up to speed with different areas of law that you're not as familiar with, and trying to balance the various demands of your internal clients. And I mentioned firefighting. In-house, you'll often feel like there's no space or time to be proactive, and you're often working in an environment that's reactive. Of course, in the private sector, it's quite different, and we work in as part of a much wider multidisciplinary team, and we get to work really more specifically on our areas of specialism as part of that wider team. And on the one hand, for me, working in governance, and obviously for James in predominantly in information law, it means we get to be part of many different projects across the firm with many different clients, which is really interesting and diverse. The downside, though, is that we don't always get to work on a project in more depth as you would in-house, where you're much more likely to see a project through from conception to birth, if you like, which is really satisfying. And I think the thing to remember there in that sense is to know your limits. Despite what your internal clients might demand of you, you can't always do everything, and it's important to recognise where you might need a bit of additional support on areas of discrete specialism. Lots of people will say that working in-house really gives you a sense of purpose to deliver for your organisation, and that is absolutely true. But I have to say, I don't feel like I've completely lost that having moved to the private sector, because I think having worked in the public sector before and then moved over, I think that really allows me to be embedded my work with the in-house teams that I support, because I've been in their position, and I understand the challenges that you face. So I think I do still get that I do obviously still get that sense of purpose there, although I'm not just working now for one client. You'll find as well as an external advisor that if you're working in the private sector, that you're more readily accepted as an independent advisor, which can be quite a difficult role to navigate if you're working in-house. Not just because it can be career limiting at times, or to have to say these things, and you may well have experienced yourself bringing in an outside lawyer to deliver basically the same message that you're trying to deliver, but it just seems to chime in a different way when it comes from an outside source. But as James has said, I mean, that's a bit of a canter through, really. There are lots of pros and cons to both. I really enjoyed working in the public sector, sorry, really enjoyed it. But I don't feel like I'm losing the key things that I missed having moved across. I think having worked in-house myself in the public sector, and just I think it really allows me to understand where my clients are coming from and those challenges, and be able to speak with them on a level that's realistic. So I really enjoy being in the private sector now. I did find that there was a lot of management when I started to progress in-house, which some people really take to. Personally, for me, I wanted to focus a bit more on the law, so that's where the private sector did suit me better personally. But if you're really keen on management, then, and that kind of the dynamic that brings, then public sector is fantastic for that. So yeah, happy to take any questions with James, and of course if we run out of time as well, then you're very welcome to contact us directly if you've got any questions. But otherwise I'd open the floor if there's time to any questions that we might have. I have to say I haven't been keeping an eye on the Q&A, but I think colleagues have and can perhaps let us know if anything's come through.
Yes, James here again. I just say from my perspective, Victoria, following up on what you were saying there, I think working now in the private sector, you have to work harder to understand what your private sector clients are dealing with on a day-to-day, because you only get a snippet, as you say, of what's going on. You might just get asked to advise on something very specific in a much bigger issue. And I think it's much more difficult to add value unless you really take the effort to understand what the client is going through, putting the advice that you're giving in the bigger context. And I think sometimes clients don't want, obviously, when you're on the clock, they don't want you to spend any longer than you need to do the job. But actually, I think it's important to try and understand a bit more about what your private sector clients are doing, because when you're working in-house, you get that because you're living and breathing it, and you can put things in context. I think certainly to add value more in the private sector is a bit harder sometimes, because you really need to either have a really regular relationship with the client and you're getting regular updates on what they're doing more generally, so you can provide not only the legal advice but kind of the commercial and practical side of things. Because I think that's one thing I found that working in-house provided me with much more kind of practicality of, well, we are where we are, these are our options, what we're going to do, and working that through. I think certainly that's something you're forced to do in-house, whereas in the private sector sometimes you're just providing the advice, particularly now being, as you said, we're specialists, and I like being a specialist now, having been an absolute generalist. I really enjoy that specialism, but also sometimes you need to understand, and it's more difficult to get under the skin of the client when you are one step removed. I suppose just going on to that question that was asked as well, because I don't think there's any questions in the chat box, but there was a question about recruitment and if someone wanted to move from one to the other. Certainly I'm recruiting at the moment, if that's not an advert, but the reality. And actually certainly I think if individuals came forward, or certainly at the moment, individuals who have in-house experience are invaluable. I think certainly you have a different skill set. You understand what clients want, maybe more. I think having worked in the private sector, in-house, in a law firm, then gone into the public sector, then come back again, you realise that your kind of mind and eyes are widened significantly once you go into an organisation like that. And I think that's a real skill set to have when you go into the private practice area. So I think there is a benefit there. I think you have, it's still that you still need the technical skills. You still need the ability to advise on the legal issues you're advising on, but actually having the experience of working in an organisation where you are potentially advising on all sorts of different issues, the politics, as you say, big P and little p, those are invaluable skills to have. So certainly I wouldn't look any differently at someone who's in the public sector compared to the private sector at the moment in recruiting. The work we do, I suppose, lends itself to having the mix of both, because you're likely to have FOI experience, for example, or lots of GDPR experience if you've worked in the public sector, because a lot of the issues we advise on are the ones you'd be advising on in-house as well. But certainly I don't see there's any detriment. I think it's almost making sure that if you're looking, I think the question was if you're looking to apply for a job, I think you should sell those skills, because they are skills that not every lawyer has. And actually it's a matter of saying, well, look, yes, I've been in the public sector and I've got a lot to show for it. There's lots of important things that you take from that job that you might not necessarily accept. But as Victoria explained, that, you know, being a bit of everything to everyone in-house is a real skill. And working with the chief exec to, you know, someone who just pops in because I've got a question about something, you know, very straightforward. That skill set is something that is a really good way of how you provide practical advice, how you deliver different messages to different people in the organisation, to different seniorities. You know, there's a skill set about delivering messages to the board that's very different to delivering messages to trainee doctors, and having to do the two was a real, you know, eye-opener and a real shift in experience. So I think certainly from a recruitment perspective, it's a matter of looking at what law firms want. Law firms want technical expertise. You know, they want hard work and diligence and meeting client expectations. We haven't talked about time recording, but, you know, that's something that is important as lawyers, and that's one of the metrics, obviously, that we get measured on. It's not the only thing by any means, and I know lots of in-house lawyers now still have to time record, but I think it's a matter of making sure that any applications you're making for jobs, if you're looking at moving either way, is focusing on, well, what does a law firm want? And it's, you know, it's all the skills you've got, just making sure you're putting those in the right way. So that's all I wanted to say. I don't think there's any questions, but as Victoria said, if there's any questions that crop up afterwards, please do feel free to get in touch after the session. I'm more than happy to pick them up if that's helpful.
Thank you very much, James and Victoria. We'll now go to legal ethics and in-house solicitors.
That's Omar. Lovely.
Morning, I've just put my camera on, so hopefully it will work.
Yes, I can see you.
Brilliant. Good morning, everyone, and just want to say a thank you to the organisers and especially to Claire as well, just for the brilliant organisation and for inviting me to speak today. Today, what I'm going to talk about today is in relation to professional legal ethics. And before I do that, just quickly, just a brief background about me. So I'm a solicitor and senior lecturer at the University of Bristol. And before going into academia, I started my career in private practice in a commercial law firm. And then I wanted the experience in litigation, so I joined the Crown Prosecution Service, and then shortly after that I worked for the Ministry of Defence as an analyst for a few years. And since 2012 I've been in-house on a consultancy basis, in-house for commercial contract, as a commercial contract and lawyer for a company that specialises in the oil and gas industry. But my full-time job is in academia. As I said, I'm also a solicitor, and what that involves at the university is I supervise students in the life client, in the pro bono clinic. And for those that don't know what a pro bono clinic is, it's essentially, it follows the teaching hospital model. And one of the things I realized is when I got into academia is my legal education was very much, this is the law, this is the settled law, apply the settled law. And when I went into practice, it was very much the same thing. You know, here's your code of professional conduct, I just read it, apply it. And one of the things I realized was missing from my legal education training is I wasn't taught to bring outside considerations into analysing the law. So it was very much, as I said, this is the settled law, law is as it is, and there was no other way I wasn't really taught or trained in, well, what should the law be, or how should I interact with my client, and how does in terms of reform, and I realised that reform of the law that is, you know, people write about and research doesn't just apply on specific areas of law, substantive law, but it also applies to how we interact and advise our clients. And that's what got me thinking and looking and reading up more on business ethics. And I realized that there was a lot that solicitors and in-house solicitors can actually learn from business ethics. And so this is really what my talk is about today, but also going beyond business ethics and seeing how we can develop, especially for example, the company that I work for, we have offices in different jurisdictions. So how, when we interact on a transnational basis or on, for global clients, is the training that we receive, is that enough, or can we actually build on that training? Next, oh, thank you. So the starting point really is to look at the SRA's report from 2008, Balancing Duties in Litigation. And in this report, the SRA stressed that solicitors are not hired gun, and the hired gun metaphor is very much, in legal ethics, it's known as the standard conception, which is you adopt a detached approach, you do whatever your client says. And the other thing as well is the issue of the zealous advocacy. So you zealously pursue your client's objectives. But according to the SRA, we're not hired guns, but the SRA hasn't told us how do we stop being hired guns. And yes, okay, we owe duties to other parties, but how do we actually identify those duties and how do we address those duties? Now, for me, one of the limitations of the standards and regulations and the principles in the standards and regulations is they're very much jurisdiction specific. And so do they really translate to global practice? And when I say global practice, it's not necessarily that we have offices in different jurisdictions. Now, in a very global environment, global world that we live in, we deal with clients who are even in England and Wales. They're from different countries, so there's different backgrounds. So how do we get to address, for example, how do we improve on our cultural competences? How do we avoid confirmation bias? And that's something that hopefully will become clear over the next few minutes. The other thing the SRA warned lawyers is against predatory litigation and placing their own interests above the interests of their clients. Next slide, please. Now, there was the title of this report, Which Way Does the Wind Blow? The full title is Which Way Does the Wind Blow? Understanding the Moral Compass of In-House Legal Practice. And this was a study that was carried out by professors at UCL, Richard Moorhead and Stephen Vaughan, who've written extensively and done a lot of empirical research on in-house lawyers' ethics. And one of the things they identified is that in relation to that, lawyers, for example, weren't familiar with the codes of conduct. Lawyers also stated that they faced ethical dilemmas, and often they were also criticized by their employers as well. So again is, well, how do we go about addressing this? And I hope that the model that I will put forward actually addresses some of these concerns that the SRA has identified, but also that lawyers have said that lawyers in-house are facing as well. Next slide, please. Bear with me while I just... So here we have a quote from the Law Society president, and one of the things I'd like to look at is what is and what isn't unlawful practice, and what are the alternatives? How do we identify our ethical responsibilities? And this is, I think, where it's important to make a distinction between ethics as rules and regulations and our duties in terms of our moral responsibilities. And this is something our standards and regulations are really silent on. They just tell us what we should be doing, and if we don't do this, then we're going to get penalized, but they don't tell us anything outside that. Next slide, please. And so a couple of questions about the limitations of the standards and regulations. And before I proceed, one thing I need to make clear is that this isn't just an attack on the standards and regulations. It's what I'm proposing is that we supplement what's already in existence in terms of the standards and regulations. So it's basically adding this extra layer in terms of our ethical duties as in-house solicitors. Why? Because they don't really promote ethical conduct. They don't tell us how to resolve ethical dilemmas. They're mainly concerned with rules rather than with ethical behavior. And also they're ambiguous. For example, act in the best interest of your client. Well, who's going to make that decision? And in terms of acting in the best interest of the client, well, there are two competing models. Is an in-house lawyer going to act paternalistically, where they place themselves as the primary decision maker, or they look at their client's autonomy and act holistically with the client? The other issue is whether it's debatable whether they apply to different types of legal practice, because a commercial in-house lawyer acting for a global company is unlikely to face the same ethical dilemmas as, say, an immigration solicitor working in Bristol, because they're facing with different types of clients, different areas of practice, and this whole issue of one size fits all doesn't exactly work. And as the SRA and the studies by professors at UCL have demonstrated, lawyers are facing these ethical dilemmas and they're not sure how to address them. In terms of the next slide, please. Thank you. In terms of the SRA's principles, so the ones I want to focus on are, how do we act in the client's best interest? And also the principle which encourages equality, diversity, and inclusion. What does that actually mean? And the other one as well is acting with independence. And for me, acting with independence doesn't just mean identifying whether there's a conflict of interest. It also means identifying whether there are any biases. And in terms of the bias, it doesn't, what I'm talking about is unconscious bias, because people who are aware of their bias, there's very little we can do for them. They've chosen to be biased. The ones that we're really concerned with is the issue of unconscious bias. And an example that I give, for example, to the students is, imagine you're standing at one end of a chocolate fountain and I'm on the other, and I throw a white ping pong ball at you and it passes through the chocolate fountain. And you don't know the color of the ping pong ball, but once you catch the chocolate covered ball, I ask you to describe it. You're going to describe a chocolate covered ball. You don't know what's behind the veneer. And this works the same in practice, is when a client tells us their issue, sometimes we supplement that or we add this veneer to what they're telling us in terms of the language that we think we're understanding, and also in terms of our preconceived ideas, whether it's through the press, whether it's through our own experiences of dealing with similar types of clients or similar types of situations. The human brain automatically adds this veneer. So for our purposes as in-house lawyers as well, how do we remove this veneer to see exactly the situation and the client that we're faced with? So we have these, the issues that are raised by the SRA, issues raised by the study from UCL regarding in-house practice, the limitations of the standards and regulations. How do we apply that to whether we work for a global law firm or whether we're in-house in a local authority? And that brings me to the model that I've come up with and I've published as well. Next slide, please. So the model I propose is a cosmopolitan client-centric model. And this model, it places the client as the primary decision maker, but also adopts a holistic approach. So, and this is where I borrow from medical ethics, in that previously in medical ethics, it was very much the doctor as the primary decision maker, whereas now there's been a move towards respecting patient autonomy and understanding the values that inform that patient's decision. And we can borrow from that in that we work holistically. And I think it was mentioned earlier about this holistic approach to in-house lawyering. It combines the autonomy model as well with the harm principle. Harm principle is from John Stuart Mill, philosopher, and basically that as long as something doesn't cause harm to others, we're free to do as we want. So a client, I'm not saying we adopt a paternalistic approach, but we highlight the harm that could be caused to others. And this is especially relevant in the current, no pun intended, in the current climate. As you would have seen in the Law Gazette recently, there's been a lot of coverage about in-house lawyers and whether they should, and law firms as well, whether they should disassociate themselves from, example, clients that are impacting on the environment, clients that are dealing with fossil fuels, and no answer really is given. But this comes back to actually highlighting the consequences that would happen. The other thing is that Cosmopolitan isn't just about our client, but it's about our own organization, because we're not just legal advisors, but we also have to draft policies, and we have to review policies and policies within the organization itself. And this is where Cosmopolitan really comes into its own, because it requires that we treat every person in our organization equally, but also that we recognize that they are different. So this then allows us to examine the fact that absolutely we should all be treated equally, but also there are differences, there are cultural differences, and it's about respecting those cultural differences and how do we incorporate those into the policies that we draft. And also this Cosmopolitan approach, it addresses issues of unconscious bias, because if I am aware that somebody has a different cultural background or just different socio-economic background, it allows me then to find out more as an in-house lawyer drafting policies that affect the organization. It lends a voice to everyone and treats everyone as part of this community. And again, this is borrowing from business ethics, where it treats the corporation as a moral entity and all the stakeholders have a moral responsibility to each other. And the other important thing as well is from business ethics is that we don't make exceptions for ourselves. So we always ask ourselves is, if the decision I want to make, can I universalize that within my organization? And if the answer is, well, I'm actually placing my own self-interest above my co-workers in terms of, let's say, promotion or pay criteria, then clearly that's a policy that we shouldn't be pursuing. And I said earlier, how do we supplement the SRA code of conduct, the SRA standards and regulations, to give it this much more cosmopolitan and transnational approach to legal practice? How do we get around the issue of pluralism when we're dealing with lawyers from different jurisdictions? And this is also relevant, what I'm going to come to in a second, relevant to firms and organizations, whether they taking part in corporate social responsibility or they have a pro bono department. And next slide, please. Thank you. And that's actually to supplement the standards and regulations, not just with a cosmopolitan approach, but we also need to look at the Universal Declaration of Human Rights. Now, this is a non-binding international document, and it has been adopted as a code of conduct in other disciplines, for example, in psychology. The value of the UDHR is that it promotes transnational legal practice because it isn't jurisdiction specific. It's not drafted with the aims that the SRA set out to when they drafted the standards and regulations. The other important aspect for us, those that are in-house in companies and business entities, is that the relevance of human rights is also found in the UN's Rights Council endorsement of the guiding principles on business and human rights. And that document was published in 2011, and another document and further guidance was published a year later, because it's recognizing that corporations now have responsibility in terms of their human rights obligations. So this essentially puts in-house lawyers at the forefront of these changes. I know it's 10 years, but it's only now starting to gain traction. So this is really my contribution to developing cosmopolitan and transnational in-house lawyers and building on the current framework, our regulatory framework. Thank you very much for listening, and happy to take questions.
So now we move to LegalTech cluster with Dagmar, Stephens and Chris Bull. Chris?
Hello, Stephanie.
Hello.
I'm here. I hope Chris is as well.
Yes, he is. Yes.
Is he? Excellent. Okay, so hello everyone. On behalf of Chris and myself, we welcome you to this very short presentation on the region as a legal tech cluster. So without much ado, can we switch forward in the slides, please? So I'm just going to set the scene as to why you should be interested in a legal tech cluster and what it could potentially mean for you and the customers of the businesses for whom you work. So there are a set range of effects that a cluster in a region can have. And I've got the impact areas here on the left in blue. So when industry and supply chains establish themselves around a particular industry sector, so for example, that could be aerospace, that could be legal tech, as in this case here, that could be a creative industries cluster. What happens typically that that growing cluster impacts certain areas, and I've got them here. So there's knowledge spillover. Basically meaning that there is a focus of skills and skills development in a limited region, which means there is more exchange between individuals and between companies and between businesses regarding good practice, knowledge base, and also skills, which then leads to, hopefully, in the right atmosphere, to a talent pipeline developing within the cluster, supported, hopefully, by institutions of further educations, by school and by higher educations. Supply chains establish themselves and grow and interlink with each other. That builds clarity for customers all across the supply chain from bottom up, because customers can identify the cluster as the place to go in order to get certain services or to get certain products, and also combinations of services and products. It builds up social capital, so we refer to that as a network or as an ecosystem around that cluster, where valuable and long-lasting relationships can be fostered and built. So that's the impact, the typical impact of a cluster. Why do we care about those impacts? We care about them because over there in green, they have certain effects, and that's what I, as a regional governmental officer, care about. They lead to an increase in productivity. They lead to competitiveness between businesses active in the cluster, which leads hopefully to a higher quality. And that then also means that you can aim, you can target certain qualities within that cluster. For example, its sustainability, its inclusivity, and it overall leads to faster economic growth. So that's the economic benefits. Of course, there are also economic burdens that can arise from cluster effects, and they are over here in red. It can mean that there's pressure on resources, and we witness that in our cluster, especially in the cities. For example, there is increased traffic, there is an increase in housing costs, there's an increase on our planning system, increased burden on our planning system. So that is pressure on resources that is being posed by growing clusters. There's also a risk of inequality. So the resident population may lose track and connection to an ever more specialized cluster with an ever more specialized requirement for knowledge and skills. And thereby people are being left out by the economic benefits that are being built by the cluster. And also a cluster can, of course, turn itself into a ghetto, into an enclave, where it loses connectivity across other industries and across the sector nationally and internationally. So it can turn itself into an echo chamber, which can lead to the decline of the cluster again. So industry, at the bottom there, industry and local, regional and national government are trying to boost the positive impact of a cluster, the economic benefits, and to restrict the economic burden that they pose, and to keep the balance between the two right. That is what my business is as head of innovation and sector development, could be cluster development at the West of England Combined Authority. And industry certainly works hand in hand with us in order to grow clusters without creating too much of the economic burdens. Next slide, please. So just before I hand over to Chris, we have a few innovation clusters already within the region, and you're probably aware of them. So I've got examples here. We've got a fintech cluster. It's an emerging cluster in accordance with a government report called the Khalifa Report. It is supported by various organizations. One of them is FinTech West, for example, a grassroots meetup organization. And currently we are developing collectively a strategy and action plan in order to grow that cluster from emerging to established status over the next 3 months. So we've commissioned a strategy and an action plan, and in autumn we will publish that strategy and we'll put the action plan in action. We've got an aviation cluster. As you know, it's supported by our universities, by the NCC, the National Composite Center, which is a high value manufacturing catapult for those of you who are familiar with the innovation system. Otherwise, don't worry. It's supported by various trade associations. It receives supply chain support. It receives innovation support around digital and design and engineering. And it is aiming itself at net zero aviation in collective action. So that is the aviation cluster. And another example is our creative cluster, which benefits in our area from various anchor institutions, our universities, of course, and then institutions like the Watershed, the Arnolfini, just to name a couple. It's got a very thriving ecosystem. That's the social value that I was talking about earlier. And it receives quite a bit of investment and support from my authority in particular, and it creates a lot of cross-cutting opportunities across other sectors. So those are examples of clusters. So now turning to the legal tech cluster, next slide, Chris will talk about what the legal tech cluster could be all about in our region.
Thank you, Dagmar. Hello, everybody. Dagmar and I started about 4 years ago, I think it was, a group called Bristol and Bath LegalTech, and you'll see BBLT as an acronym appear on some of these slides, and you'll have seen it on the intro slide. And I guess back then when we started it, Dagmar I think was still at University of West of England at the time before she joined West of England Combined Authority with her innovation role. I was, as I pretty much am today, a consultant and advisor to legal service businesses, mainly law firms around the UK and around the world. And we're both based here in the region. We had a hunch, I guess, that there was a legal tech cluster forming in the West of England, and that it had some significance, perhaps nationally, perhaps internationally, but it wasn't really adhering to any of those criteria that Dagmar just outlined. It was formative, but we wanted to see whether we could help stimulate it and develop it, and working with particularly a great input from Bristol Law Society, as well as from West of England Combined Authority and some of the universities and some of the law firms in the region, I think we've been able to do that, and we would now say yes, there is a cluster here in Bristol and Bath and the surrounding areas. It has got real significance, and the other thing, which I think particularly with Bristol Law Society we've been able to answer, is the question: well, how is this important? Is it fundamental for the future health of a regional legal sector to have a legal tech element and to develop and build that? And I think strongly people in lots of different roles, including through the court system and hopefully in-house, would feel that the answer to that is an emphatic yes. We have to continue to develop this and build this part of the legal industry in order for us to have a healthy regional legal market. So we've done quite a bit of work in building a community of people from all kinds of areas, from universities, from institutions, from government, from law firms, of course, over the last, and from tech companies, particularly from the tech sector, over the last 3 or 4 years. And earlier on this year, we published what effectively was a check-in. It was an opportunity for us to seek some independent, objective view of how the cluster had developed, how important legal tech was and was going to be to the region and the region's legal sector, and some of the strengths and weaknesses. And what I'm going to do, just the final bit of this, is talk you through some of the outcomes and the conclusions that report, which was commissioned from a company called Whitecap Consulting, that report showed us. First of all, before I do, always just worth saying, okay, legal tech, what is it? What are we actually talking about? And everybody who comes at this and uses that phrase, or law tech, which some people prefer, tends to have a slightly different interpretation. So on this slide, we just covered quite a few of the different ways of describing it. From over on the left-hand side, kind of how digitization effectively, how the impact of technology and moving from a much more kind of manual, in-person legal industry to something that's far more digital, how that changes the industry. That includes all the aspects of justice. It includes how lawyers themselves work. It includes how they interact with clients, and there's a big access to justice element in there as well. Can we use technology to create a lot more access to legal services for individuals? And then over on the kind of right hand side, there's legal tech, which is often seen as quite a disruptive, potentially revolutionary, transformational tool to really dramatically change the way that the legal supply chain works. So disrupting, innovating, substituting traditional legal service provision, which, by which we mean probably, done through solicitors and barristers in firms and chambers in fairly traditional ways. Can legal tech solutions products actually substitute for some of that? And that's of interest, I know, to many in the in-house community who think, well, maybe there's a different way of getting some of the legal support and service we need from third parties than just going to law firms and paying what we've always paid. And then this idea of disintermediation, that basically technology through compare the market type products, through web-based interfaces, through collaborative networks can sort of provide a different route in, different channels in for people. And then down at the bottom, just this whole idea that legal tech is providing constant stream of new products and services. And we can look at other tech sectors. Banking is a great example, and financial services, as Dagmar's already flagged, to see what's happened in those sectors where you've seen entirely new product ideas arrive. So that's what we're talking about when we're talking about legal tech. Next slide, please, and I'll just talk you through some of the things that came out of the report. So this is one of the key pages from the report that was published earlier this year into our Bristol and Bath region cluster. And there's lots of stats on this. I've put a link in the chat if you want to just download the full report. It's a good read. It looks quite nice. It's quite easy to read, but there's a lot in it. So I would recommend you take a look at it if you've got any interest in this subject. But there's some big stats there, and some things that came out quite strongly about how powerful the region's legal tech ecosystem already is, and I think we still feel it's quite potential. And some really key numbers there. At the top right in particular, if we look up there, we've got in the region 15 legal tech companies. We've got more than that now. Certainly we found more. It's like looking under stones. I found another legal tech company. So businesses that are tech companies that are focused on the legal sector that are here in the region. So that number was 15, which may not sound like a huge number, but when we compared it, and Whitecap compared it with other regions, it comes out very strongly. And that number's growing, as I said. Strikingly, we found arbitrarily a precise number, 769, over 750 individuals working in legal tech roles. Now, some of those are working in IT jobs in big law firms, many of them servicing lawyers from all over the world from their Bristol or Bath base. Some of them are in tech companies, some of them are in universities and other areas, but incredible legal tech workforce, and again growing all the time. What we found from the survey is lots of businesses, different types, said we're hiring more of these people with tech skills or innovation, design skills who can work in the legal sector. And then there was a really big theme, and many of you will already know this from where you may have trained, or the work you do and the work you pass out to third-party law firms. Is Bristol has a surprisingly large number of law firms who are headquartered here, have grown perhaps from a Bristol or Southwest base, or has got branch offices of large national firms. So that really drives the amount of legal tech activity that's happening within law firms, which the report concluded was particularly high in the Bristol and Bath region. And I think from your point of view, one of the things that should just be bells ringing, if it's not already, is we need to make sure that we're getting enough from the law firms we use in terms of insight about technology, what it could do for our in-house team, how we could be made more efficient, because the firms, particularly in the region, many of you will use a lot of them, have done a lot of work in that area and continue to develop it. Next slide, please. I'm just going to flick up the next slide, because it's kind of become the icon from the report. It's not actually the front cover of the report. It's page 3 or 4, I think. But this is an attempt, already out of date, inevitably 6 months later, to show the Bristol Bath legal tech ecosystem, and lots of logos here. Firms, lots of firms up in the top section there, and chambers, and then alternative legal service providers and legal techs as we go off towards the right. Some fantastic companies, some of whom are working exclusively in the legal sector, legal techs, some of whom which we've badged as tech suppliers, who are more generalists but are doing a lot of work in the legal sector, either with law firms or with in-house. And then sort of round over onto the left, we've got a lot of kind of other component parts funding or consulting or advising on the sector. So that's just an example really of what's in the rest of the report. And as you can imagine, when we released the report, published it and promoted it up on social media, we got a lot of interest in this kind of view of the world. And we'll keep developing this, not every year, but we'll try and keep this updated. And then final slide, please. So some recommendations here that came out of the report. It wasn't just a sort of puff piece that said, wow, fantastic, great legal sector. It also dug a bit deeper, and I've mentioned some of these things already, particularly 1, 2 and 3, the strengths that the sector has built on this large number of law firms, lots of head office, lots of people working in legal tech, some great legal tech companies. There were also some suggestions for development. Number 4 in particular is one of those, and I think that's probably a cue into the in-house community in the region, which we all admit we haven't managed to engage with as well as we'd like to. And we did get some in-house input, and some of you on this event may have had some contributions. I spoke to a number of people about their use of technology, what they expect to happen in terms of their in-house environment in relation to use of technology. But we do need to collaborate more, bring that in-house community in. So please, if you are interested in this, or somebody else in your department is interested in the use of technology to make you more efficient, more automated, more streamlined, whatever it may be, maybe move some of the work from traditional kind of we're using external law firms to a different model. We're really interested in your input. We're going to be running more things through Bristol Law Society around LegalTech over the next year. Do read the report. The link is in the chat, or just reach out to me or Dagmar or to the team at BLS to say, look, I'm interested. What can I do? What can I get involved in? There's lots of stuff coming up soon, including final plug. On Monday, the 11th of October, we've got a LegalTech event running as part of the big Bristol Technology Festival. It's third year we've done a LegalTech event, and it's kind of basically everything you ever wanted to know about LegalTech, but we're afraid to ask. It's a chance to come along, ask questions, hear a view from a fantastic panel of experts. Right, I'm going to wrap up because I think you've got a break, well earned and deserved. Thanks, Dagmar, for joining me on this, and thank you everybody for listening.
We should now be back from our comfort break, so welcome back from our comfort break. I'm now going to hand over to Jackie Weaver, Chief Officer, Cheshire Association of Local Councils, who's going to speak to us on good governance and resilience. Jackie, pleasure to meet you. Over to you.
Thank you, Stephanie. I mean, first of all, I'm going to repeat what I've just been saying to Stephanie, which is I personally find this far more intimidating than doing live TV and learning to use an auto cue for the first time on live TV. So by comparison, that was a doddle. And I say that because for me, this is very much more important. This is the kind of thing, issues around town and parish councils, issues around local democracy. These are the things that I have been interested in and involved in for 25 years. The other stuff is relatively new, but of course the other stuff is what gives me the openings to be able to do things like joining you this morning. Now, please do not think for one moment that I am touting myself as an expert in these matters at all. I'm not an expert. What I do have is experience. So, I mean, most of you, and I don't know whether it's mercifully I can't see you or sadly I can't see you. Most of you will know me, I guess, from the telly and from media. And you will know me from a virtual council meeting, parish council meeting, that went viral. Now, I certainly have a lot of experience where we've had difficult meetings. We don't promote them. We don't kind of air our dirty washing in public, and often we try to kind of smooth over it so that it sounds like everything's tickety-boo. But I have had a fair experience of difficult meetings, but that one, I think that was a corker. Why? Personalities involved. We'd had, I think, 3 different monitoring officers involved. We were burning through them quite fast. And I think it was literally years, I think that council had just built itself to a point where it was going to break, and no amount of intervention was going to stop that. And there was something about the way that the people themselves kind of conveyed their frustration and their, in some ways, arrogance, that I think really shocked people, but at the same time was incredibly funny. So I think there's something there about, men in this instance, sorry, men, not all men are like this, of course, men of a certain age behaving like children who just stamped on their own toy. And are now screaming about it. Because, of course, those of you that have spent some time even looking in a little bit more depth at the meeting itself will have spotted that that wasn't the first meeting of the night, and the earlier planning meeting went exactly the same way. So that I would have thought, as I approached the meeting for the second time, I was increasingly anxious about it, thinking, what new strategy will they come up with for disrupting the meeting? And then they did exactly the same thing again, which I thought was incredibly weird. But it didn't have any effect the first time, but who knows, might have had an effect the second time. It didn't. So it was kind of like a really crazy time around that. I mean, certainly nobody in our sector knew how to deal with the sudden media attention. And yet it's the very thing that we've been talking about wanting for, in my case, 25 years in the sector, because it has been incredibly difficult to get anybody to pay any attention to town and parish councils. So that, I mean, although I think every journalist in the land has cut their teeth at a town and parish council meeting, suddenly when it comes to talking about them, they've all forgotten that. And it's like they're discovering these town and parish councils for the first time. What do they do? Where are they? Where will we find one? Are they all like this? So it was a really weird time for all of us. But I guess for me, I recognise that if we are serious about trying to increase diversity in local councils and really encourage people, communities to get involved, then if we have this media attention, we have got to grasp it with both hands. And I guess that's what I've done. I think the other thing for me is I am in many ways lucky that I am 63 years old. I have had a really good career. If it stopped tomorrow, I would reflect back on it and be happy with it. If the media attention stopped tomorrow, I would talk about it for many years to come. And none of it is something that is essential to my well-being, if that makes sense. So I'm aware that I talk from a different position than many people in our sector. Because I'm not a younger person trying to maintain a home, a job, a career, a future, a mortgage, all those kind of things. I don't have those pressures on me. And I think sometimes that is something that gives me the opportunity to speak out more forcefully than younger colleagues who are in employment. That's a kind of personal perspective. And don't get me wrong, it has been fun. I mean, the kind of things I've been asked to do have been weird. From the first day that we've had media attention by people turning up on the door the following day, up until yesterday was in Leeds doing Steph's packed lunch, dressed as a Bond villain. I kid you not. And reading the 1 o'clock views, kind of spoof on the news, for the first time using an auto cue on live TV. And there's never any assumption that anybody says to you, are you able to do any of these things? So as we're kind of going into the studio, and the person that's looking after me says, have you used auto cue before? No. You'll be fine. It's kind of like the stock answer to everything, you'll be fine. So if we think our life is pressurised, I can only say that by comparison to working in the media, and I don't have any responsibility for the media, somebody else is making it all work. The idea of working at that level of anxiety day in, day out, I don't think there are many people that make it in the media to 63. So that's incredibly good fun. And I've had a laugh, and there's been lots of opportunities, for me to. I've had my own podcast, and recently just launched a book, which I might tell you a little bit more about later. But all of that is kind of like a currency, which enables me to talk about things I think are more important. Although Steph's packed lunch is, of course, supremely important. So I spent 25 years in local government. I've been a councillor. I didn't like it. It wasn't for me. I mean, I think that people kind of look at me and think that I'm a kind of people person. I'm actually not. I much prefer to be the person in the background. I've referred to myself before as a magician's assistant. I much prefer to be the one that navigates the way through the problems for other people to deliver their agenda. I don't particularly want to set an agenda, but what I do feel very strongly about is fairness. And when I see something that isn't fair, that really troubles me. So, and I keep saying this, 25 years in local government, I've been counsellor. It was not for me. I don't like being nice to people. I've been a clerk, and I quite enjoyed that, but I was clerk to a small council, and I felt that there was more that I could do. And eventually, after about 3 years coming back after taking a break from children, I became the county officer for the Cheshire Association of Local Councils. Now, I often feel quite uncomfortable saying that I worked there, I still do, worked there for nearly 25 years, because that sounds like, I don't know, it makes me sound like an elderly bank manager. Very comfortable, perhaps drinking too much these days, and waiting for retirement. And actually, it's not been like that, because the parish council world of 25 years ago is very different from the parish council world today. And the Cheshire Association of Local Councils is very different. I think the best way of conveying that is to say, when I was first appointed, I worked very part-time hours, less than 10 a week. And we operated on a budget of about £7,000. We now have 3 members of staff, and we have a budget of about 140,000. But we do look after 230 odd parish councils. So we still punch, I think, way above our weight in terms of supporting those local councils. So we've changed because our local councils have changed. And just as the principal authorities have had less and less money and have, in my view, contracting, what we're seeing is an expansion of our parish councils to take up that slack. And that itself is problematic. Because although we, for example, the Liverpool report talks about the importance of training counsellors, we have no way of requiring mandatory training. And now we have parish counsellors that come into the business with no training at all. And just as principal authorities are now being asked to make decisions on, well, one of our larger councils, 2 or 3 million. And I think that's quite scary. The introduction on the agenda suggests that we have an increasingly hostile environment. I'm not sure we do. And again, your experience may well be different to mine, but my lived experience is that hostility has been there for a long time. And I think often it is part of I think in your world it's part of the politics. In my world, less politics, but more personality. So that when we're talking about communities and we're talking about town and parish councils, there is that, literally physical nearness of councillors and their electors to each other. And often, particularly in rural villages, the disputes that you might be dealing are not just between 2 councillors, they're between 2 families that have been going on for at least the last 50 years. So I think that hostile environment has always had the potential for being there. I think it has always been there, but I think it's been largely hidden because of the way we conduct our meetings. Zoom meetings, other formats are available, but Zoom meetings have been, certainly for us, a challenge in the beginning and a necessity at the end. So that in conjunction with the LGA, the National Association, and anybody in their cat really, we're all asking government to reintroduce legislation that enables us to continue with Zoom meetings. I say that because the National Association survey shows that we have at least a 20% increase in attendance at council meetings by the community, and a 20% increase in the number of hits that websites are getting. So there is quite a big growth in people looking at what's going on in my local council. And that's got to be something that we welcome. But I think for me, the other thing is about that spotlight on bad behaviour. And I think that so much of the poor behaviour that we see in councils, the problem is we don't see it. And it happens behind the scenes. So I guess I'm kind of thinking about what happens when we prepare to return to Zoom, because it has to. I mean, surely the fact that for me, it feels very much that the Houses of Parliament are reluctant to hold virtual meetings or even quasi-virtual meetings, and the rest of us are suffering from that. but certainly out in the communities, local government would most definitely benefit from it. So I hope that, when we've heard the conversation that government want, ultimately we are able to return to some form of virtual meetings. But we need to prepare for them, because I think we had the assumption that virtual meetings were just council meetings with a screen, and actually they're not. There are other skills that are needed. There are other operational matters that need to be considered, because I think that we are spending an awful lot of time worrying about where the buttons are. I certainly know I was doing that night, rather than paying attention to what's happening on the screen. And although it's a very visual meeting, and we kind of assume that everybody just knows what they're doing, I think chairmanship plays a huge part in how well a meeting is conducted and how well the behaviour is conducted if the chairman has the appropriate skills. And again, certainly for my sector, we offer chairmanship training, because often the right person is not put in the chair. And when I say the right person, they may be the right person for the community, but they may not be the right person for managing the meeting. Another thing we're thinking, it's been something that's been promulgated for a while, is whether or not at our level we could in fact do with splitting out for town councils particularly the chairman role with the mayoral role, the kind of civic role, because again often those are two very different skill sets and interests, and it may be that separating them out would be extremely beneficial. There are kind of ways of doing that behind the scenes informally. Certainly we've explored them in Cheshire, and it has had some positive impact on those local councils that do it. So I guess that I wonder whose job it is to make sure that we do actually have positive behaviour. And again, I kind of feel that I speak with some authority on this, no pun intended, having had the experience of, in the case of Cheshire, moving from a 3-tier authority to a 2-tier authority, and having some well-documented challenges with one of those authorities. So for me, it's, this is not rocket science. I really appreciate that, and these are not terribly original thoughts. But for me, it starts with leadership, and that kind of seems to be on two fronts. One is the head of paid service, and I have been privy to a succession of chief executives that certainly don't lead. And it's also about the leader of the council and the relationship between those two, because I think that they need to demonstrate from the top what behaviour is appropriate. And I think it's also really important we have clarity about the procedures for what happens when things go wrong. I mean, all of you, I guess for me, it's often when you're involved in something and you understand it and you've stopped reading the guidance because you don't need to anymore, you forget how ridiculously complicated it is because it's now simple in your mind. So I know that when I talk about governance issues and when I do training and code of conduct, for example, there are certainly times when I talk about the procedure where it sounds like you are literally making it up line by line. And again, I think we have some responsibility there about the language we use and how complicated we make it. I know that the underpinning legislation is extremely important, but I'm not sure it actually has to find its way into the documents themselves. So I think there is an opportunity there for really simplifying the information that we give out to other people. If you followed me in any way, you'll have heard me talk often about the code of conduct, and comment here is really, can we have any confidence in a system that produces reports that might run to upwards of 100 pages? What's that about? I mean, that's not about an incident being reported. That's about a life story, surely. And if we have a policy or procedure that calls out bad behaviour, why do we wait until the behaviour is unbearable before we take any action? So that when the first sparks of poor behaviour occur, why are we not taking action at that point? And part of the reason that we don't take action at that point is kind of wanting to protect our dear monitoring officer. So we think it's too trivial. It's too trivial. Let's just let's suck it up. It'll get better. So actually, what happens is that when the report goes to a monitoring officer, it is several pages long and it is complicated, and everybody has a view on it. And then, even when we've gone through that 100-page report, what then? The worst sanction you can have is somebody making you read the report, because ultimately the only sanction is that you might recommend training, and you might, in fairness, remove a member, or suggest the council removes a member from committees, but that's hardly a sanction. And I wonder if at the moment, although we petition to try and introduce change, introduce sanctions, and we try to encourage people to just generally behave better, it's so difficult to change the behaviour of others. Sometimes it's easier to change our own behaviour. And certainly in my experience, I find that when we have a difficult member, the whole, certainly at town and parish council, it will be principal authority, but the whole council business begins to revolve around this particular member. And everybody seems to be taking double the effort to appease the member. So every time an email comes in from them, oh, right, must do something about that because it's from. And actually, what we do is that we reward really bad behaviour. I actually have a counsellor, a very difficult counsellor, God knows how many pages this report's going to go to, who is on the record as saying, I know I'm a bully, but it's the way I get things done. She's proud of it. And what's happened is that because he bullies, officers react to that. They don't want that behaviour, who would? So they give him as much as they can of what he wants as quickly as possible. So we're creating a circle there that absolutely rewards bad behaviour with positive action. And often the advice I give to my team is slow it down. Use the system. Because there's nothing we can do to them, in reality, there's nothing they can do to us. So why are we jumping through hoops every time they ask us to? Put it on the bottom of the pile. Don't reward the bad behaviour. And I think that, I was referenced the Liverpool City Governance Report. And I think the only words you can use on that are frightening. And I wish I could say, I have no idea what they're talking about. But actually, just as we've experienced in Cheshire, we have some parish councils that have better governance than the principal authority. And who's responsible for that? I find it incredibly difficult to think that it's members that are responsible for that rather than officers. I remember a chief executive doing a presentation to one of our parish council conferences, which was intended, I think, to give us an incredible reassurance at how well the principal authority was doing. And I listened as she explained how they were introducing this new raft of policies. I just sat there, open mouthed, thinking, I just assumed you had all of those already. How can you stand in front of me and tell me that you haven't got these policies? Like things like whistleblowing policy, things like a dignity at work policy, things like a member officer protocol. How can you say you didn't have these things? What were you praying at? So sometimes I think we don't always have the right people at the top. And I suppose the question is, how do we get them? And for me, I think that comes back to the diversity issue. I mean, you have to work diversity in as best you can to anything, so let's go for it again here. For me, I think one of the sad things about local government is the lack of engagement by people. So that I'm mainly talking about town and parish councils, where I'm able to say, it's been really difficult, there's no money there to do it. You know, you really want to tell people how they can influence local democracy, local decisions, and I'm talking really, really local, like town and parish councils. But if they don't even know they're there in the first place, how can we encourage people to get involved with them? So for me, part of it is about encouraging people to stand. And that way, the more people that will stand, the more opportunity we have for greater diversity and people who have greater capability in helping us make those decisions. And they are decisions like making sure we recruit the right chief officer. So enough about the lecture. That really sounded like I was trying to beat you up over it, and it certainly wasn't my intention. I think it is a difficult system, and I think I recognise that. But I think there are, as I have suggested, some things that we can do that will in fact help support the system while we try and affect change. But I'm also really mindful that actually we're still talking about people here. I know we're talking a little bit about process as well, but ultimately my experience has been of several monitoring officers, and it's usually a monitoring officer that I deal with, over several years. And often they have had very different approaches. And I guess that for me, what I've seen is the approach of very formal, very last line, last stop, come to me when everything else has failed, to the very approachable, offering support, literally offering support at that point where things are beginning to go wrong, not before they've actually gone wrong. And in my opinion, the second approach works better. That early involvement of the monitoring officer is hugely important, but monitoring officers themselves and their team need supporting. So I guess for me, again, it's kind of, I think monitoring officers of course need to come with authority. We've got to have that feeling that, that they have power. But I wonder how we actually use or wield that power. And I ask you to look at yourself, your own experiences. Are you easy to talk to, or are you scary? Now, you might think you're easy to talk to. I might find you scary. So it's, are you approachable? Is it easy for people to get in touch with you? I know a terrific monitoring officer, and one of the things that I think makes him a terrific monitoring officer is that he exudes calm and authority, and he's the kind of person that I automatically, I mean, people think I do that, but when I'm with him, I feel reassured automatically. He's warm and friendly and calm, but he is authoritative, and part of that I think comes from the fact, one, he's a man, and two, he's physically large. Even when you kind of meet him across the screen, he's physically large. And I wonder if that is a challenge for us as women. So that, if we don't have that as a kind of natural expression of ourselves, how do we find it? Because it is a really powerful way of engaging with people. So I have some suggestions. I guess, first of all, find your own support mechanism. We all have a different one. I hope yours is not alcohol, because that's going to go downhill really fast. But hopefully you have some other mechanism that you can turn to, whether that's counselling, not as sound counselling, or whether it is actually just talking to colleagues. It can be a really powerful thing. The other thing is fake it until you find it. People often say to me when they're talking about the Handforth video, how did you were remarkably calm, how did you do that? Oh, who says I was remarkably calm? You mean because I wasn't crying or shouting back at them? Well, if that's the only definition of calm that we need, then I think we could all manage to do that. And pick your battles. I think that's for me another really important thing, is that I see clerks who burn out. And part of the reason why that happens, I think, is because they do treat everything with the same level of importance. And every aspect of governance is not equally important. So there are other organisations out there that can be extremely helpful. I am with the Cheshire Association of Local Councils, but you will have county associations in your county. And often they are incredibly helpful when it comes to working with town and parish councils. And that's pretty obvious, but they, like me, will have had experience of dealing with these issues and can often do the informal stuff behind the scenes that perhaps you as senior officers can't do. And in closing, I just want to say everything I've talked about is easily said and not so easily done. So be kind to yourself, and when you can do that, be kind to others. Oh, and go and buy my book for more helpful ideas. I'm happy to answer any questions.
Thank you very much, Jackie. Jackie Weaver, Chief Officer, Cheshire Association of Local Councils. We don't, for the moment, from what I can see, Jackie, have any questions, but I'm sure if we keep an eye on the chat, the Q&A, people will put questions in there. But can I thank you very much for your informative presentation. So now we're going to turn to decarbonisation and the route to net zero, presented by Deepika Keen, Head of Business Transactions Knowledge, co-lead of Tackling the Carbon Challenge UK, and Caroline Bush, Senior Associate, co-lead of Tackling the Carbon Challenge UK, Osborne Clark. Over to you, Deepika. Thank you very much.
Thank you, Stephanie. Yes, as Stephanie says, I'm Deepika Keen and I've got a very long title, but effectively at Osborne Clark, I co-lead the team that looks at decarbonisation policy and regulation. I'm a corporate lawyer by background and I've been practicing for more than 20 years. My journey to decarbonisation sort of began through an interest in responsible business practices and sustainable business. My fellow speaker is Caroline Bush. She's my co-lead. Oh, I'll let her introduce herself anyway. But I just wanted to start off by thanking Jackie. What an interesting and engaging talk. One thing that struck me really was what you were saying about getting public engagement in local government and that being a really key aim. Well, the subject of this talk is something that has, huge levels of public engagement. So perhaps you in the audience are facing the opposite problem when it comes to this topic, where you've got lots of interest and it's a vast topic that it's difficult to get a handle on. So Carol and I are aiming to demystify this for you. It's obviously a particularly topical session with COP26 that's due to take place in November in Glasgow, and Caroline will explain what that's all about. And also, obviously, we've got energy policy being front page news at the moment. So Caroline's going to explain some of the big picture background underpinning the net zero race. And I'm going to look at some of the recent policy announcements in the UK. And then what we thought would be quite useful is to do some jargon busting, just look at some of the common terms that you're going to come across when dealing with this topic. We're conscious that we're standing between you and lunch, so hopefully we're going to stick to our allotted time of 20 minutes. So on that note, I'll hand over to Caroline, and if you could just move the slides forward a couple of slides, that'd be great. Thank you. Thank you. Yeah.
Thank you. And actually probably just onto the next one, and then I think that covers off. Oh, and the next one again. Goodness me, we did lots of lovely kind of middle slides. So thanks, Deepika. My name is Caroline Bush, and as Deepika mentioned, together with Deepika, I am co-leader of Osborne Clark's team looking at decarbonisation policy and regulation. My practice area is environmental law, and I'm looking particularly at issues relating to climate change, sustainability and biodiversity. So today, just to set the scene, I thought it'd be useful just to spend some time thinking about the background to COP26 and why this COP is particularly significant. Now, don't all switch off now. It is a complex area. There's lots to cover. We haven't got long. So we've really picked the key elements only. This is not an exhaustive summary, and apologies to anyone on the call who knows all about this. I know that before researching this stuff ahead of a webinar I did last November, I didn't know very much about it. And I think sometimes it's shrouded in a bit of mystery. So what is COP26? It's the 26th session of the annual Conference of the Parties to the United Nations Framework Convention on Climate Change, or UNFCCC. So the Framework Convention itself unites nearly all countries in agreeing that climate change is an important issue, and it seeks to combat it by stabilising emissions of greenhouse gases. It was negotiated by the UN following the 1990 Intergovernmental Panel on Climate Change report, which showed that human activities were increasing concentrations of CO2 and that average global temperatures were rising. The Framework Convention was adopted in '92, and all parties to the Framework Convention are part of the Conference of the Parties, or COP. Decisions and resolutions of the COP make up the rules for implementation of the Framework Convention. There's also the Kyoto Protocol you might have heard of, and that's essentially the protocol to the Framework Convention. In 1995, certain parties to the Framework Convention adopted a declaration that commitments were not adequate, the commitments made under the Framework Convention. And this is what led to the Kyoto Protocol, which was adopted in December '97 and came into force in 2005. It is what imposes legally binding commitments to achieve greenhouse gas reduction targets on national governments. And it set a target for developed countries collectively to reduce greenhouse gas emissions by an average of 5.2% below 1990 levels in the period 2008 to 2012. So coming back to COP26, why is it significant? Firstly, just in terms of numbers, it aims to bring together over 30,000 delegates, which includes 200 world leaders, climate experts and campaigners, and the goal is to agree coordinated action to tackle climate change. It's the most significant climate summit since COP21 in Paris in 2015, when the Paris Agreement was adopted. And it's expected to cover obviously lots of areas, but particularly areas where agreement was not reached at COP25, and those include offsetting carbon and financial aid for developing nations. It also aims to finalise what's called the Paris Rule Book, which are the rules needed to implement the 2015 Paris Agreement. But what is the Paris Agreement? Often talked again. So it was, talked about. So it was adopted at COP21 in Paris in 2015 by 197 countries and formally ratified by 189. Some of its key elements include driving efforts to limit global increase in temperature to well below 2 degrees C and to limit warming to 1.5 degrees C above pre-industrial levels. So that's where that 1.5 degrees C, which is often talked about, actually comes from. It also aims to achieve peak greenhouse gas emissions as soon as possible, then to reduce them to achieve net zero emissions in the second half of this century. And it requires what are called nationally determined contributions, or NDCs, from each party country, which set out national climate action plans. They are required to be as ambitious as possible and to be reviewed and tightened every 5 years, i.e. ahead of COP26. It also talks about assistance to developing countries by providing climate finance to adapt to climate change and to switch to renewable energy. So finally, for me, from the global perspective, a few recent headlines that you might have picked up on. There was a recent UN report that concludes that the current pledges on emissions from national governments, so those NDCs I mentioned, would actually result in a 16% increase in emissions by 2030. So clearly work to be done there. There are also questions as to whether the aim to secure $100 billion in public and private climate finance before COP26 is actually achievable. This is a central tenet of COP26, and that money is to help developing countries transition to low carbon technologies and to cope with extreme weather. That fund was bolstered by the commitment you might have picked up on from President Biden at the UN General Assembly just last week to double climate financing to $11.2 billion. And it's also worth noting, of course, that over $80 billion has already been secured, which is in itself positive and presents considerable potential opportunities, for example, to developers working in the area. And then finally, at last week's UN General Assembly, also China promised to halt the funding of coal-fired power stations overseas, although I should add that questions do still remain over its domestic efforts and its revised NDC. So now I'll hand over to Deepika to talk about what is currently in place in the UK.
Thanks, Caroline. So next slide, please. You're my best, Chris Whitty. Thank you. So in the UK, the main piece of legislation is the Climate Change Act 2008, which was the first law to make cutting emissions a legal obligation on successive UK governments. And the aim of the Act is to cut emissions while allowing the economy to grow. Initially, it required the UK to reduce greenhouse gas emissions by 80% by 2050. But in June 2019, the Act was amended so that the target was increased to 100%, i.e., we need to achieve net zero emissions by 2050. Now, the UK was the first G7 country to set a net zero target for emissions in national law, but that's now being copied. For example, Europe is looking at a Europe climate law, which will again enshrine net zero into European law. 2050 is a long time frame, so the Act introduced the concept of carbon budgets. These are legally binding maximum levels of net emissions which the UK economy is allowed to emit during successive 5-year periods. And the 6th carbon budget is for the period 2032 to 2037. And the importance of that period is that to meet the carbon budget for the 2030s, the UK has to take action now. So in effect, that 6th carbon budget is the budget that's going to set the policy directions for the next 10 to 15 years. Those budget recommendations are made by a UK scientific body known as the Climate Change Committee. It's an independent statutory body established by the Climate Change Act, and it advises governments and monitors their progress. It's got to take into account climate science, relevant international developments, and also the cost effectiveness of its measures. So this 6th carbon budget is the most recent one that the government adopted, and it adopted that in June of this year. Sitting behind that target is something that the Climate Change Committee calls a balanced pathway to net zero. And these are the extremely detailed recommendations for the whole host of policy decisions that's going to give the UK the best chance of achieving net zero. It's essentially a roadmap for decarbonisation policy for the next decade. So to give you a sense of what's coming in terms of policy, for financing, for example, UK low carbon investment each year is going to have to increase from 10 billion in 2020 to 50 billion by 2030, and then it's going to have to continue at that level through to 2050. So we're already seeing government funds being set up to fund low carbon initiatives, and each of those are going to have to ramp up. There also needs to be a focus on a just transition. There needs to be a fair strategy to deal with the shift of hundreds of thousands of workers out of high carbon roles into low carbon ones. Also, the benefits of the transition, such as better insulated homes, cleaner air, quieter streets, more access to green spaces, all of those need to be shared broadly across the population. And finally, when you're talking about a just transition, you need policies that provide a competitive level playing field across the globe. So we've got common standards. So those are kind of the high level picture developments. In terms of the near-term actions, i.e. in the next kind of 15 years, it's going to fall into 4 main areas. The first one is around reducing the demand for carbon and improving efficiency. So, for example, improving efficiency in heating is a major topic at the moment. I'll talk a bit more about that. Number 2, encouraging people and businesses to adopt low carbon solutions as high carbon ones are phased out. So, for example, the electrification of transport and also the electrification of heating. You might have heard stories about gas boilers potentially being phased out in the next 10 to 15 years. We already know that petrol vehicles are going to be phased out. Industry also is going to need to adapt, either adopting electricity or hydrogen instead of fossil fuels. and the government's already talking about industrial clusters switching their production and having co-production of low carbon fuels. 3, there needs to be expansion of low carbon energy supplies. So by 2035, 100% of UK electricity will be low carbon compared to about 50% now. And the largest contribution for that is going to come from offshore wind, but also low carbon hydrogen production is going to scale up. At the moment, it's pretty negligible, but by 2035, it's going to represent about 1/3 of the power sector. And then the 4th and quite important element is around land management and carbon removal. So we'll see an emphasis on tree planting, agricultural land shifting to bioenergy production, peatland restoration, and so forth. So that's what we should be doing, and we're seeing lots of high-level policy announcements from the government to do with that. So there's a national infrastructure strategy, there's an energy white paper, there's a hydrogen strategy, but you know, the devil's in the detail and in actual implementation. So how's the UK doing on that scale? So there is some good news. We've seen a sustained continued reduction in UK greenhouse gas emissions, and there are official estimates that by 2020 we'd reduced our greenhouse gas emissions by 49%. So ostensibly we're nearly halfway there. Also, on a positive note, since the Climate Change Act was passed, governments have met their obligations under the Act, and the framework of the Act has strengthened the use of evidence in policy making, which is always a good thing. And generally, both the Act and the Climate Change Committee's work is strongly supported by policymakers, businesses, and the population at large. But, and there's always a but, isn't there? Currently, emissions are not falling quickly enough to meet that net zero target. And the most recent independent assessment by the Climate Change Committee, which was published in June, shows that the UK has fallen behind significantly. And that's because the reductions that have happened already have largely been done because of the decarbonisation of the energy sector, of energy generation. So, you know, increase in solar capacity, wind power, and, you know, that's all low-hanging fruit. It's the more difficult sectors, transport, heating, building infrastructure, agriculture. These are the areas where work is needed now, and those are the more difficult sectors to decarbonise. So just to finish, what are some of the key issues for organisations? So there's a real change of pace in carbon literacy. People are becoming more and more aware. They're including ESG principles in procurement processes. And obviously from tomorrow, you'll probably most of you will be aware that having a net zero commitment is one of the mandatory requirements when it comes to public procurement over, I think, for contracts over 5 million. There's also increasing recognition that investment for net zero is crucial for the future. So the finance sector is really leading the way. There's a mixture of voluntary and mandatory rules, but we think that net zero compliance is going to become a condition of finance, which is obviously going to drive the private sector quite significantly as well. Lots of organisations are not waiting for legislation. They're setting their own net zero goals. But we are warning organisations that they need to be careful about greenwashing, not setting net zero targets that don't stand up to scrutiny. You might have seen in the press, for example, there was a case brought by green campaigners in The Hague against Shell, which they succeeded in. So I think the rise in litigation risk for organisations is significant. And obviously, you know, locally we've got the current controversy about Bristol airport expansion. Lots of organisations are investigating the use of carbon offsetting, which we'll talk about a bit more later on. But I think it's fair to point out that we're likely to see a standardisation of offsetting solutions. So if you're putting offsets in place now, you need to think about the fact that they might be subject to regulation later on, and generally just more transparency, accountability, because the current voluntary market is likely to become regulated. So that's it for the legal and policy background. I'll hand over to Caroline to begin some jargon busting.
Thank you very much. And if we could have the next slide, please. Oh, and the next one. Thank you. Perfect, that one. So I'm conscious of time, and hopefully this will be helpful as well. And thank you, Topeka. That was brilliant. So I guess here we just think there are quite a few mysterious sounding concepts in the world of decarbonisation. So we picked what we think are some of the key terms, and we'll just give a little overview as to what they are, what they mean. We're not scientists by background, so please excuse us, any scientists who know more about this than us. So to start off with the net zero and net zero target. So this is achieved by balancing the amount of emitted greenhouse gases with the equivalent emissions that are either offset or sequestered or captured and stored. Now, clearly a net zero is primarily achieved through a reduction in carbon emissions, but where these cannot be reduced to zero, they can also be offset through carbon credits, which Topeka mentioned, or sequestration through, for example, rewilding or carbon capture and storage. And a net zero target simply requires achieving net zero by a specified date. Many organisations are setting targets by or before 2050, and that's largely to align with the Paris Agreement I discussed earlier. By contrast, a commitment to carbon neutrality does not actually require or even necessarily imply a commitment to reduce overall greenhouse gas emissions. A carbon neutral business needs only to offset the greenhouse gas emissions it produces, even if those emissions are actually increasing. So it's a slightly different term. Net zero itself is sometimes criticised for various reasons, including that for businesses, there's no real definition requiring action outside of that company's operations, meaning scope 3 or value chain emissions. I'll come back to that in a bit. And those can clearly make up a large part of a company's carbon emissions, and those can be excluded from a company's net zero target. Also, to align with climate science and the Paris Agreement, a net zero target should really include incremental targets that increase carbon reduction ambitions over time. So a company or a nation which sets a net zero target for 2050 will need to act on that target now and not wait till the 2040s, for example. And net zero also runs the risk of relying overly on offsets rather than reducing carbon emissions as far as possible first. A company could maintain emissions at a steady level using carbon credits or offsetting mechanisms to reach net zero, which essentially negates the need to actually reduce its own emissions. However, I guess it is worth saying that many might argue the concept is not perfect. It is driving real change, and I think our view is it's better than nothing. So a carbon footprint, this is the total annual greenhouse gas emissions caused directly or indirectly by, could be an individual or an organisation, or even a particular event or product. The carbon footprint will include direct emissions, also known as scope 1 emissions. So these are emissions from activities within an organisation's control, and indirect emissions, or scope 2 and 3 emissions. And those are emissions from sources outside the organisation's direct control. A product's carbon footprint takes into account the whole life of that product, goods or services, and that includes as a result of the extraction of raw materials, so right at the start, its manufacturing, use, maybe reuse, recycling or disposal. And I think the concept might be useful, for example, when an organisation is assessing the overall environmental impact of its products and its operations, and also, of course, in meeting CSR obligations. Organisations may also want to calculate their supply chain carbon footprint, and that's the total annual greenhouse gas emissions resulting from the purchase of raw materials and also services by that organisation in order to deliver its services and products. You might also have heard talk of a science-based target, and this is quite simple actually. It's a target to reduce greenhouse gas emissions that's in line with what the latest climate science says is necessary to meet the goals of the Paris Agreement. So an emissions reduction target is defined as science-based if it's developed in line with the scale of reductions required to keep global warming to less than 2 degrees C above pre-industrial levels, and to pursue efforts to limit global warming to 1.5 degrees C. And that would be, that target is as validated and published by the Science-Based Targets Initiative, or SBTI. So finally, briefly, I've touched on scope 1, 2, and 3, but I guess just to give an example, scope 1 emissions are all direct emissions, either from the activities of an organisation or under its control. And examples include on-site fuel combustion and emissions, also refrigerant losses, for example, in company vehicles. Scope 2 emissions are indirect emissions from electricity or heat, for example, and those are the things that are purchased and used by an organisation, but the emissions occur at sources which are owned or controlled by another company. So in electricity, the electricity company is actually responsible directly. And then scope 3 emissions are all indirect emissions, which are not scope 2 emissions, that are also a consequence of the activities of the organisation, but occur from sources not owned or controlled by the organisation. So those, it could include business travel, procurement, waste and water.
And under the greenhouse gas protocol, which is the kind of standard for these considerations, companies should separately account for and report on scope 1 and 2 emissions as a minimum, but reporting on scope 3 emissions is optional. And the last point from me on this is that under UK carbon reporting legislation known as the Streamlined Energy and Carbon Reporting Regime, or SECA, certain scope 3 emissions, such as transport emissions, do need to be reported on by certain companies. And generally reporting on scope 3 emissions, while currently voluntary, is encouraged. So it may well be that reporting on scope 3 emissions becomes mandatory in the future. So there may be some benefit in gathering this data where possible. So I'll now hand over back to Deepika just to pick up on the last few terms.
Thanks very much, Caroline. I think we are sort of running out of time slightly. So I will just quickly gloss over these terms. They're to do with the pricing of carbon, and putting a price on carbon is one of the biggest challenges of our time. Carbon pricing is essentially allocating the costs of greenhouse gas emissions to the sources of those emissions. The various kind of options that we can use, a carbon tax. We don't have a carbon tax at the moment, but we've got indirect taxes on fuel. But instead we have an emissions trading system, which covers some limited parts of the economy. And this is where emitters within the scope of the system get given allocations of carbon credits, like an allowance. And if they exceed their allocation, they have to buy additional credits. If they don't use them, they can sell them. So this carbon trading is that process of allocation, sale and purchase. It's probably worth talking about the carbon border tax here, which is being pursued in Europe, a carbon border adjustment mechanism. So that's a tax on imports so that the price of imports more accurately reflects their carbon content. It stops areas where we've got high carbon regulation like the UK and the EU, stops production being transferred to areas where there's low carbon regulation or imports of cheaper carbon intensive kind of replacements. And finally, as Caroline said, carbon offsetting, it's a mechanism for claiming a reduction or credit by referring to reducing greenhouse gas emissions elsewhere. So often a tree planting project is a classic kind of offsetting project. Offset credits are criticised quite a lot because they might not actually contribute to emissions reduction. So you should have some caution if you're using offsets. The big message for offsetting is that it should be the last resort. The first step should be to reduce emissions as much as possible. And finally, lots of offsetting projects involve nature, and that's where we come to nature-based solutions. So they're solutions that use nature to reduce carbon emissions. You might hear about mangrove restoration projects. That's a classic nature-based solution. So if we just move on to the next slide, which is our wrap-up. And the next one, please. Thank you. So in terms of takeaways, the legal obligation to achieve net zero rests with the government. But it is enacting policies to achieve that aim. So while there's no direct legal obligation on businesses, for example, to achieve net zero, all organisations do need to start adapting for a net zero environment. Climate change risk is something that your organisations and all of your stakeholders are all going to be engaged with. If you haven't already, start speaking to your suppliers, your employees, your customers, your wider stakeholders. Many organisations are making their own voluntary net zero commitments and are planning for the transition. So if you haven't done so already, you should consider that and start engaging with what you could be doing to achieve your organisation's aims. We've got a free decarbonisation self-assessment questionnaire on our website that gives you a snapshot of where your organisation currently is on the journey. And we also have a timeline that shows the legislative and policy milestones leading up to 2050. Again, that's on our website. So I just want to wrap up by saying thank you very much for your time. Feel free to contact us if you've got any questions. It's a huge topic and we've only scratched the surface. If you'd like to hear more, we're running a decarbonisation webinar programme, which you can sign up for and hear more details about greening supply chains, for example, carbon offsetting, greenwashing, green jobs, and so forth. So thank you very much.
Thank you very much, Deepika and Caroline. I now welcome to the stage Mary Jackson, Director of Education and Training from LawCare, who's going to speak to us about wellbeing and the future legal landscape. Mary, welcome.
Thank you very much. Good afternoon, everyone, and welcome to, I think I'm the last speaker for the morning that you've had on wellbeing and the future legal landscape. I think just picking up on what the speakers have just said, I think the future is already with us. And this webinar follows very much hot on the heels of the launch of the results of our survey, Life in the Law, which I will be talking about towards the end of the presentation. So let me begin by asking you a rhetorical question. Here at LawCare, on the front of our leaflet, which we redesigned about 4 years ago, we put in a speech bubble the words, "How are you really?" Because so often when we ask someone, "How are you?" they say, "Fine, thanks, you know, the pandemic, whatever." But at LawCare, through our support channels, which are, of course, the helpline, live chat, and confidential email support, we dig deeper to find out how you're really doing. And we know that this continues to be a tough time. It's not a normal time. We now have a fuel crisis to wrestle with, and things are still feeling a bit raw, a bit new, and a bit uncertain. And issues that we're picking up on through our various channels are the whole vaccination debate. To vaccinate or not to vaccinate among young people. Then we hear from our callers about how happy or unhappy they are with working from home, the hybrid model, or returning to the office. We also have this whole thing about relocating to the countryside. I live, like many of you, I guess, up there in Bristol today or elsewhere in the southwest. And we've seen a massive influx of new property owners to the southwest because they now feel I can work from home, I can live anywhere. And of course, the attendant spike in property prices. And then there's still the whole debate about whether we should go abroad or not. So there's a lot of things to be concentrating on at the moment, and that might make us feel, oh, I'm not that great. But I'm hoping by the end of this webinar, I'll be giving you some ideas to take away to help with your well-being. So what does it mean? It's a word that's bandied around so much, and it really is just about being well. And of course, at LawCare, we're particularly concerned for our lawyers and all those who work in legal organizations, because health is often compromised in the legal profession. More about that later. So it is about being healthy, both in your mind, your mental health, and of course, physically, your body. And here's the World Health Organization definition of health. It's a state of complete physical, mental, and social well-being. So it's not just about the absence of disease or infirmity. And here I've just listed the many dimensions of health. So at LawCare, I would say we're there to help with your emotional needs, emotional crises, but there's so much more to the concept of health. The pandemic has taught us the importance of social health and feeling connected to people. Occupational health, how you're feeling as you listen to me working as an in-house lawyer. And then, as we've just heard from Deepika and Caroline, the huge issues that affect the entire world. The health of our environment. And at LawCare, we're just in the middle of writing an environmental policy. So those are just to remind you of the many dimensions of health. So why is it hard to be a healthy lawyer? I'm often asked, why do you work on a helpline for lawyers? And one reason, and there are many, one reason I think is that as a lawyer, and I am a former lawyer myself, our brains are actually more wired for negativity. They go more towards the negativity bias. So law in the workplace. As a lawyer, you have to be prudent. It goes without saying. Inevitably, there's a touch of pessimism there. You're there to solve problems for your client. Also, overthinking, rumination. We heard a judge on the helpline recently who said she's still thinking about a judgment handed down 12 years ago and it's affecting her sleep. Then there's the perfectionist approach. The devil is always in the detail as a lawyer. Documents, emails, letters, phone calls, you have to be as perfect as you can be. And none of us are Mary Poppins. And also I find, having talked to many in-house lawyers over the years, particularly with in-house lawyers, there's a big element of self-sufficiency. You might be the only lawyer in the business, for example, so you're thrown back on yourself a lot. And the legal workplace, as we know, is always competitive, pressurized. We have a culture of long hours. I don't quite know where that came from, and that came up in the panel discussion last night about this ingrained idea of almost having to work long hours. I remember when I was a solicitor being told, yeah, you may think it's 9 to 5:30, but it's 9 to 7, and some nights 9 to 9. It's also hierarchical, often, and as I've already said, a place of negative emotion. So I'm not here to give you an anatomy lesson, but to start you thinking about how you think. So I've called the next little section, Getting Your Head Around the Legal Brain. And here are what I think might be some in-house thinking styles, and feel free to put anything in the chat box that you want to add. Prudent, I've mentioned, proactive, analytical, logical, critical, a focus on the needs of the business for your client, decisive, of course, commercial acumen, and there are many others. So those are in-house thinking styles, and they're a big ask of the brain. As human beings, we remember traumatic experiences better than positive ones. We recall insults rather than praise. I can't be the only one who, when I have my appraisal, I remember maybe the 1 or 2 criticisms, constructive criticisms, rather than the praise and the thanks. We are wired to react more strongly to negative stimuli and to naturally think more about negative things than positive, responding more strongly to negative events. And it all goes back to when human beings began their life on Earth. We had this inbuilt stress response that really helps us, but it always remains alert and on. And these days, the stressors are not saber-toothed tigers, brontosauruses, or whatever. They tend to be deadlines, emails, the other side, long hours, work, home life, imbalance, and all that. And as an in-house lawyer, here are some of the more negative ways of thinking that you might have. You'll be sitting there thinking, well, what can go wrong here? Whose fault is it? Where's the liability? What if we don't win or get this through? Or if there's a settlement involved, what if the other side don't accept the settlement? And I'm here just to give you a few ideas for ways of developing more positive thinking. Our brains, still the least understood organ, are malleable. They can be changed and adjusted. This is the science of neuroscience. And one of the things, I was a teacher before I became a lawyer, and I was asked one day, what's one of the big differences between the two professions? And this one instantly came to mind. I said, you know what? I'm hardly ever thanked for the work I do, and I'm never praised. I hope that's changed in many legal organizations, but my helpline experience would suggest that it hasn't. So the next time somebody in your team, even a non-lawyer, does something really good or achieves a result, give them a bit of praise or thank them. And this idea, 3 things that you are grateful for, our brain responds very positively to this. In the morning, or perhaps last thing at night, think of 3 things. Now they can be very small. I'm going to start by saying I'm really grateful to Claire Ponting because she's here operating the slides, doing a very fine job. She also kept us all informed throughout about exactly what was going on. So I'm grateful for Claire Ponting. I'm also grateful that the sun is shining through my window today and I got my washing out very early this morning. And I'm grateful to Bristol Law Society for giving me the chance to tell you a bit more about law care, and I hope give you ideas for helping the work-life balance. Maybe think about monitoring language. Lawyers and language go hand in hand. Instead of this, I should have done this, I ought to have done that, why didn't I think of this? Try and adopt more constructive phrases, or catch yourself when you're really being critical and say, would I talk to my best friend like that? Or would I talk to a child like that? So try and dampen down that inner critic. Try and challenge that little voice. Now, the current models of working, as we understand, and this is anecdotal really, what we hear through the helpline, live chat and email is different words. So there's mostly a hybrid model. It tends to be 2 days at home, 3 days in the office. Another way, I rather like the word agile or blended. Some people are having to go into the office because of demands of clients, or perhaps there are very confidential documents or whatever, and it seems that there are rota systems in place for that, which is great to hear. As far as we know, court hearings and tribunals remain virtual, although I do know of a coroner's court where they're sitting in real time and space. And I'm just wondering, as I talk to you, how happy you are with your current model of working, and I'll leave that there. In the final 10 minutes or so of this webinar, I'm being a bit of a revolutionary here. And this is very much arising out of life in the law and my own views. I've been at LawCare 13 years, and I've listened to a lot of lawyers and people working in legal organizations in that time. So wouldn't it be wonderful if we had organizations where actually there were no defined targets, or maybe there were team targets rather than individual targets, where there was less of a hierarchy, so a more flat structure, a more team-led business. The next one, we have a real thing about at LawCare, because one of the most common phrases throughout the pandemic was, I'm really worried about phoning my supervisor. I don't know when I can interrupt her. He always seems really busy with his family. And I'm scared that I'm going to be told that everything is hopeless or whatever. And I would say even a few minutes supervision, if you are in a more junior position, makes a huge difference. Or if not that, regular space in the diary. Acceptance of mistakes. And this is so difficult for lawyers. I once had a colleague who hid a file, not at LawCare, who hid a file in a cupboard for a year before it was found because she had made a mistake on that file. And of course, the chickens came home to roost. Better to admit it and get something done about it. No bullying. Sadly, that was one of the 3 major reasons for calls to our helpline last year, and it seems to be escalating. Bullying, stress, and anxiety were the 3 most common features of our contacts in the past 18 months. And wouldn't it be wonderful if we could all work a 9 to 5:30 day? I won't even talk about a 4-day week, which I know is being trialed in certain organizations in New Zealand at the moment. And then to have very clear boundaries between work and home. So you're not sitting there at 8 o'clock at night thinking, oh, I'll just get that email off because it will save me thinking about it overnight. And that will all ask for a culture of growth and a whole change in this ingrained way that we have, this culture and practice of law, and also shared values. Now, I'm sure that you are like me in that throughout the pandemic, I was always looking for hope. I was looking for more positive news, and every so often I would completely disconnect from my phone, laptop news, because it all seemed so grim. Even this time last year, we were to go to Cornwall and there was an outbreak of COVID and we never went. And this young woman I found truly inspirational, and you will know who she is, Amanda Gorman. She was the young poet, beautifully dressed in yellow, who spoke so passionately and movingly at the inauguration of President Biden. And I've just taken a few little snippets from her beautiful speech, which she called The Hill We Climb. We know our inaction and our inertia will be the inheritance of the next generation. And, you know, having just listened to that bit about climate change, it kind of hit home, those words. Our blunders become their burden. But the new dawn blooms as we free it, for there is always light. If only we are brave enough to see it, and if only we are brave enough to be it. And it does take courage. Changing anything takes real courage. What if we were not afraid of hitting targets, making mistakes, going on holiday, missing deadlines, the client complaining, being blamed and having too much, too little work, or daring to say, I can't cope just at the moment? Now, I've just had a message through to say that I need to wrap up. So I'll go through 3 more slides and then I'll stop. So here are a few more ideas, which I took from the resolution.org.uk article by Gillian Bishop. And she talks about less litigation, more sharing of best practice, proper scheduled supervision, debriefing, allocation of work, I've already mentioned collective targets, and more training, perhaps at college, university level, in client management skills and in boundary development. Okay, so I was going to do this exercise with you, but I won't. It's the idea, though, of pausing in your day for just 1 minute. And I'm just going to leave you with these thoughts, that perhaps consider mindfulness as a way of dealing with stress, being kinder to yourself. It was the theme for Mental Health Awareness Week last year. And also recognizing that you're not alone. If nothing else, the pandemic proved that over and over again. And I loved that slogan about being alone together. Claire, if you can just whiz along to the very last 2 slides of my presentation. I just want to tell people a bit more about Law Care. So we offer a helpline 9 to 5:30 on weekdays, confidential email support, live online chat, usually on a Wednesday, peer support. Last year, we allocated 77 peer supporters. Fit for Law, which is a great free online resource if you want to develop your emotional competence and professional resilience, and lots of fact sheets, and so much about life in the law, which we launched last night. And I will leave you with one final thought, which I think is on next 2 more slides along. Those are tips from Law Care, Fit for Law, as I've mentioned, and then the final slide. So you've had a lot of food for thought today, very inspiring half day's work, I think. And I'm just leaving you with a rhetorical thought, which is, what will you do with the gift of your left life? Which are words from our former poet laureate, Carol Ann Duffy. I'm sorry it's been so quick, but remember, Law Care is there for all of you as a resource and a help. And thank you very much for attending.
Thank you very much, Mary. So it is my absolute privilege to bring Bristol Law Society's in-house conference to a close. And what a morning it has been. I'm sure all our delegates have found the session to be insightful and engaging, and to have left you buzzing with ideas to take away with you. And what a fantastic lineup of diverse speakers today, both in terms of legal field and experience and equality characteristics. It has been a delight to chair the conference, and yet another reminder of the ongoing innovation within in-house practice. It is also not at every conference that we are able to hear from the maestro of governance and accountability, Jackie Weaver, though I'm pleased to say our panels have been a degree less boisterous than perhaps what Jackie is used to. I would like to thank all of our speakers for the time you have given us across the morning to share your experiences and insights. We have touched on an incredibly broad range of areas today from across the spectrum of legal practice. I hope that you were able to connect virtually with each other as well, whether to discuss what you have heard from today's session or to share your own valuable experiences and to learn from colleagues. So briefly, we heard from James and Victoria about in-house lawyers facing public law obligations and transparency and accountability obligations. We heard from Omar the need to be aware of the code of conduct and the SRA rules and to promote ethical conduct. From Dagmar and Chris, legal tech is important, as is the need to access, provide legal advice in different ways and get legal support from all sectors. And Jackie Weaver, media attention will help diversity and inclusion of the profession. And finally, we heard from Deepika and Caroline that provided useful background to COP26 and carbon credit trading, which sounds interesting and something to watch out for the future. And finally, Mary from LawCare. Mary from LawCare, who provided us with valuable LawCare, who provides a valuable service to lawyers in terms of emotional support, and of course is one of my nominated charities during my presidential term. So, as Jackie Weaver said, find your release and your own support mechanism, know your triggers and be kind to yourself. And of course, Mary left us with those lasting words. So as we emerge from the pandemic, adapting to the changes in our working and business practices, leaders will be looking more than ever to in-house lawyers and their teams to provide strategic advice and support that will be critical to navigating these changes. Everyone here today plays that role, not just as a legal advisor, but as a business advisor, driving forward innovation and helping to shape an organization's risk culture. Whether it is identifying and helping to mitigate risk or meeting regulatory requirements, your advice and input is essential. And the Law Society wants to provide the opportunities you need to advance your careers and to access support as and when you need it. And I would encourage everyone here to join our in-house division, which can support you with this, as well as providing you with more opportunities to meet with your peers and colleagues. Again, I would like to thank everyone who has attended today, especially our speakers, and to Bristol Law Society for arranging such a superb conference. I'm sure many of us will meet again at next year's conference. So please do have an enjoyable afternoon. Thank you and goodbye.